I'm the editor-in-chief of the Richmond Public Interest Law Review. Welcome to our symposium, Trust, the Judiciary and Movement Lawyering, Legal Avenues for Justice Inside and Out of the Court. Thank you for being here, and just a housekeeping note, if you want to sneak out and get more food, we're going to leave the breakfast out for another half hour or so. But first, I'm going to introduce Dean Wendy Perdue, who will be giving our welcoming remarks. Dean Wendy Perdue is a recognized leader in legal education. She is a past president of the Association of American Law Schools, a former vice president of the Order of the Coif, and she has held a number of other significant legal positions, including the editorial board of the Journal of Legal Education and the Board of Governors of the Virginia Bar Association. Her scholarship includes civil procedure, conflict of laws, land use, and public health. And her publications include 2 casebooks and numerous articles and chapters. And it has appeared in the Virginia Law Review, the Northwestern Law Review, Washington Law Review, and the Journal of Law, Medicine, and Ethics. Before joining the law school as dean in 2011, she was the associate dean and professor of law at Georgetown University Law Center. Join me in welcoming Dean Wendy Perdue.
Thank you very much, and welcome everyone. It's great to have you here. A particular welcome to any of our alums, but welcome to everybody. This is a really terrific and timely program, and I commend the Pillar Journal for conceiving it and putting it together. Trust, the judiciary, and movement lawyering. Trust, we're running a little short on that at the moment. And giving serious thought to what to do about that is one of the pressing issues right now. The judiciary is having its challenges as well, certainly in part related to trust and to other activities within the current environment. And movement lawyering, just thinking about working for justice. And the lawyers who have really committed themselves to that enterprise of working for justice. It is so important, and I'm very grateful to the Journal for putting the program together and for all of you for coming to participate. So I will turn things back over to the Journal to launch the first program.
Thank you, Dean Perdue, for your incredible introduction to our lovely little event. And good morning, everyone. I am Sarah, another Sarah. I am one of the Symposium editors for the Public Interest Law Review at Richmond Law, and I am delighted to welcome you all to our annual symposium. We are so happy to have you all with us today. Our event, as discussed, is entitled Trust, Judiciary, and Movement Lawyering, Legal Avenues for Justice Inside and Out of the Court. We have some truly incredible speakers here today, and they're here to offer their insights onto these very pertinent subjects. Before we get on any further, I would like to thank some very important people who made this event possible. First, thank you to our wonderful speakers. We are so grateful for the time you are spending with us today to offer your expertise and experience. To everyone in attendance today, thank you for coming to what Sean and I affectionately call our little nerd conference. We are sure it's going to be a great time, and we are excited to have you here. For their immense support in planning, coordinating, and executing the symposium, I would like to thank Mary Ruth Keyes, the Associate Director of Communications and Events, Will Thompson, the Budget and Events Specialist, Maggie Graff, the Digital Communications Manager, Sylvia Yanis, the Director of Public and Instructional Services, and our wonderful Carl Ham, the Multimedia Project Manager. To our illustrious Editor-in-Chief, Sarah Harker, my co-editor, Sean Mattox, our Managing Editor, Claire Pitzer, and our Director of Programming, Emma Sauer, thank you all for your dedication and your care. I'm honored to have worked with you all. When Sean and I first began discussing the kind of event we wanted to put on, we came to a conclusion quite quickly. Both of us were looking for answers at the time. Answers on what it means to use legal practice to help our communities. Both of us were feeling the current pulling away from stability and trust in the courts. Trust in the court system, especially in the US Supreme Court right now, is unusually low. According to a survey from the Pew Research Center from last year, trust in the Supreme Court is the lowest it has been in 3 decades. The conversation about judicial accountability and Supreme Court ethics has been opened a couple times in recent years and garnered some discussion. Perceptions of courts as political have also increased in recent years. According to the same Pew Research Center survey, the national conversation about judicial independence has gained significant traction. Lately, there's been a feeling in the air, some questions. How much do we really trust the courts? Do we think they can always ensure just outcomes? How confident are we that we can continue to use the courts to help our communities? These questions then led us to ask, what makes us find trust in the courts? What's different now than it used to be? And what would it take for us to regain trust in the courts? More than that, it led us to ask, how else can we use the law as a tool to help our communities? The American legal tradition has a storied history of using the law, especially through court cases, to secure civil rights and gains for our communities. A lot of what we focus on in law school are the big cases, the Supreme Court cases, the class action lawsuits that secured what the law is today. But then the question becomes, especially on smaller scales, how can the law be leveraged still to ensure gains for our communities without getting to the Supreme Court, without relying on big names or systems we may not fully trust? How can we use legal avenues to find and create justice? These are the questions that led us to organize this particular event and to invite these very specific speakers. Before we continue to our first speaker of the day, I would like to offer a definition and some context for the phrase movement lawyering. Movement lawyering, also known as community lawyering, is a practice of using the law to build power of communities and social movements. The goal of movement lawyering is generally to collaborate with communities to confront oppression inherent in our global political economy. Basically, movement lawyering is all about using the law with and for communities and social movements to advance their needs and goals. As you can tell from the program, the event is split into 2 thematic parts. This morning, we'll focus on trust in the courts. We have an incredible set of speakers with a wide range of expertise and perspectives to talk about this. And after lunch, we will move on to movement lawyering. Again, we have some very remarkable speakers, and they will be offering their diverse perspectives on legal practice with a community focus. We hope today offers you fresh perspectives on trust in the judiciary and community lawyering. As community members, scholars, lawyers, and law students, we need to build trust within our communities and with each other. We need to serve our communities. Pillar is a journal dedicated to public interest and community service. I sincerely hope today's discussions are interesting and inspiring in this regard. Welcome, everyone. Before we begin the day in earnest, I am honored to introduce our very first speaker, Professor Tobias. Professor Tobias holds the University of Richmond School of Law's prestigious Williams Chair and writes in a number of areas with a particular emphasis on federal judicial selection. A prolific scholar, Professor Tobias is an author of over 120 law review articles and the author or co-author of more than 80 essays, commentaries, and other shorter law review works. He has published in the country's top law journals, including the Stanford, Columbia, California, and Cornell Law Reviews, among many others. Professor Tobias is also a frequent commentator in the media and has written several hundred opinion pieces published in the Washington Post, Los Angeles Times, Christian Science Monitor, State and Politico, and among other high-profile media outlets. He has served as a legal consultant to the Food and Drug Administration and the American Bar Association's Commission on the 21st Century Judiciary, as well as a member of the District Court Local Rules Review Committee of the Ninth Circuit Chief District Judges Conference, the Civil Justice Reform Act Advisory Group for the U.S. District Court for the District of Montana, and the Study Committee to review the Nevada Rules of Civil Procedure. Professor Tobias has been a member of the prestigious American Law Institute since 1994. And on a personal note, for many of us in this room, Professor Tobias has been incredible to have class with. In his panel, Professor Tobias will introduce the basics for the types of judicial selection around the US, the different types of judicial selection processes for the federal judiciary, and the various forms of judicial appointment in state judiciaries. These will include partisan and non-partisan elections, appointments, merit-based selection appointments, and the different types of selection processes will also move to outline the different positives and negatives that may arise within these different selection pathways. Welcome, everyone, and welcome, Professor Tobias.
Let me know if you can't hear. I think it's Carl Hom has set me up so you can hear me. Please feel free to interrupt or ask me any questions if I'm unclear. But my goal is just to try to set the stage and explain the state and federal courts' architecture and talk some about the selection processes that apply in each one. I'll start with the state courts and start with Virginia and then move to the federal. So in Virginia, we have one Supreme Court. We have 7 justices whom the General Assembly elects. They serve 12-year terms led by a Chief Justice whom the justices elect. All justices hear most cases, but some cases are heard by 3 justice panels. Most cases have oral argument in Richmond, but occasionally justices will sit in other locales around the state. Then there is the Court of Appeals. It's the intermediate appellate court, which hears cases that arise mostly from the circuit courts. There are 18 judges on that court who serve 8-year terms, whom the General Assembly elects, led by a chief judge, whom the court's judges elect to a 4-year term. Hears most cases throughout the state, and the idea is to cover the whole state and then sit in 3-judge panels all over the state. So the state feels that people are represented in Southwest Virginia, on the Eastern Shore, Northern Virginia, South Side, and across the Commonwealth. So that court basically elects its chief judge, who serves for a 4-year term, and sits usually in 3-judge panels. And so you have a tiebreaker in most situations. Occasionally, for a small number of appeals, they will sit en banc, which means that the whole court hears it, except it's not all 18, it's 13, because 18 would be difficult at best. In the federal system, they had some experience that wasn't very good when that many judges were on the court. The Fourth Circuit, of course, which is our appellate court in the federal system, does have 15 judges, so when they have en banc proceedings, it can be difficult, but they're so courteous that everybody gets a chance to ask questions. So then in the state system, again, circuit judges are the trial courts of record, whom the General Assembly elects for 8-year terms, who sit throughout the state in circuits comprised of cities and counties. Their peers elect the chief judges for 2-year terms. And then finally, there are the general district courts, which have more limited jurisdiction over less complex cases. Those judges are elected for 6-year terms and serve throughout the state. So the judicial selection process for Virginia judges, the Supreme Court justices frequently are elevated from the Court of Appeals because they are most like the Supreme Court justices. But occasionally they come from the practicing bar or sometimes from the circuit courts. The General Assembly elects them, attempts to have representation from all regions on the Supreme Court. So there's someone from Southwest Virginia and people from other parts of the state, so that everyone feels that they have some representation on the Supreme Court. The same applies as to the Court of Appeals. General Assembly members who represent the areas where judges will have chambers frequently suggest candidates, and the General Assembly often agrees with the delegation's members and schedules those chosen for interviews before the Senate and House Courts of Justice committees. General Assembly typically defers to the delegation members' recommendations and elects those candidates. Some observers suggest, and I'm not among them, that the interviews can be less rigorous than analogous hearings convened in the federal system by the U.S. Senate Judiciary Committee. However, that may reflect the fact that federal judicial nominees, if confirmed, enjoy life tenure, rather than what happens in Virginia, where the judges have renewable terms. So if you're a Supreme Court justice or you are a Court of Appeals member or even a circuit judge, your term can be renewed if your service has been satisfactory, and that usually happens unless there's some question about the competence or ethics of a particular judge, which is extremely rare. So then let's talk a little about the selection process. Generally considered to be effective in the state and to yield judges who are well qualified, fair, and honest. Some observers suggest that the federal system with presidential nominations and advice and consent is more effective, but some states model their processes on the federal approach. So some states model their processes on the federal approach with gubernatorial nomination and advice and consent of a Senate and House in the particular states. South Carolina is the only other state where the legislature elects the judges, and even there they have a nominating commission that makes recommendations. So we're one of a small number of states who have the system that we have, but it has served Virginia well. Most other states subscribe to election of judges by the people who live in the state, which is considered to be more democratic in certain ways. If judges are going to sit in judgment of the citizens in the courts, then those states believe that that is appropriate. There are criticisms leveled at judicial elections. One is the notion that elected judges can make them appear to be politicians in robes, as people have said, rather than dispassionate, neutral decision makers who resolve cases on their law and the facts, rather than political predilections. These concerns are compounded by the issue of money in elections. I think some of you are familiar with the recent Supreme Court election in Wisconsin, where millions of dollars were poured into the campaign just last year. And that has happened in many other states, Michigan and Texas and other places where much external money is contributed to campaigns. These concerns are difficult. They are and may erode respect for the candidates who win election by making them appear to be politicians who can be bought and sold. Responses to these concerns are restrictions on campaign financing and the activities in which judges participate, which can make them seem to be politicians. So that's the state, or a quick look at state systems. In the federal courts, I want to turn to now, you have the U.S. Supreme Court comprised of 9 justices whom presidents nominate and the Senate confirms to life tenured service. There are 179 appellate judges who serve on 11 regional circuits around the U.S. The D.C. Circuit in the District of Columbia is considered the second most important court in the country because of its cases, which often involve the branches of government and other extremely important issues about governance and the way the branches of government interact. Congress has also placed very important jurisdiction in that court. For example, in the environmental area, under the Clean Air Act, all appeals of regulations have to go to that particular court. So there's also the Federal Circuit, which hears intellectual property cases and a number of other suits where Congress assigns the court jurisdiction. There are also Article I courts created by Congress. Examples are the Court of Federal Claims, administrative law judges, and many agencies and departments have ALJs and immigration judges who certainly have been overloaded and under fire recently. There are 677 district or trial court judges. Here we're in the Eastern District of Virginia. There's also the Western District of Virginia and 93 districts across the country. The circuit and district judges have life tenure. Magistrate judges are appointed for 8-year renewable terms by the district judges, a majority of those in active service, whom the magistrate judges help resolve cases. Magistrate judges cannot try felonies, but can try civil cases with the consent of the parties. There are also bankruptcy judges who are attached to district courts and appointed by the circuit judicial councils and handle cases where people declare bankruptcy, and companies and other entities. Selection process for justices and appeals and district judges are quite similar. The president nominates candidates for vacancies and the Senate provides advice and consent. Appellate judges are deemed more important because their rulings bind district judges in all states within specific appeals courts. District judges cannot bind anybody, even in their own courthouse, though they are the workhorses of the federal judicial system because they hear the cases, they settle 90% of them, but they are prepared to try cases when they need to. The magistrate judges are extremely helpful because the district judges are overloaded in many districts. And so they lean heavily, and we're blessed with having great magistrate judges here and in Western District of Virginia as well. And they make the courts function in ways that allow them to keep their heads above water. So the history of judicial selection is unclear and contested. tends to be quite controversial. Many observers believe that selection remained comparatively uncontroversial during the 18th and 19th centuries, and even as late as 2000. And that is because the judiciary was relatively small in size. The major political parties were relatively or comparatively collegial, and the system was just less controversial than before 2000, then it became after that. Some observers trace what is called the confirmation wars, which are characterized by partisanship and politicization of the processes, and I'll describe that in just a bit. But much of this, people believe, came to a head in 1987 when President Ronald Reagan nominated Robert Bork, who was on the D.C. Circuit, which is the second most important court in the country, had been the Solicitor General, who became somewhat notorious because he fired the special counsel who was investigating President Nixon at the time. But in any event, he was one of the leading scholars in the nation, ideologically conservative, and had been conservative on the D.C. Circuit. And he was nominated. It was pretty controversial and contentious. And he was slated to take the vacancy created when Lewis Powell, who was from Richmond and served for about a dozen years, decided that he would retire. And what this meant was that the balance on the court, which existed at that time, coming forward from the Warren Court, which was comparatively centrist or liberal at the time, would switch with Bork's appointment. And so Democrats perceived that to be a difficult situation. Joe Biden was the chair of the Judiciary Committee at the time, and I think it's fair to say that he led the opposition. But he did, of course, extend a hearing to Bork, but ultimately what happened was that there was not confirmation, and the vote wasn't very close. A number of Republicans did join the Democrats in that situation. So ultimately, Ninth Circuit Judge Anthony Kennedy was nominated and confirmed for that seat, and he turned out to be a relatively moderate member of the court, and he also was the deciding vote on a number of important cases that some of you may know. What happened in 1992 with the abortion case, basically upholding Roe versus Wade, when he was joined with O'Connor and Souter in writing the opinion, and a number of other important cases, especially involving LGBTQ rights, and Obergefell, and he resigned a while ago. So in any event, actually during the first Trump term. So that was taken to be a kind of turning point. I think that overstates it. There have been times when there have been controversial nominees, and in fact, in the 19th century, about a quarter of the president's nominees for the Supreme Court were rejected by the Senate, which is much higher than happened subsequently. So there have been periods of contention. But I think that that we are at a point where it has become increasingly controversial. And I'll talk just for a bit about that. It's become more contentious, partisan, and less cooperative. Important reasons for this phenomenon, or these phenomena, were application of the filibuster to the selection process, the rise of partisanship, and growing politicization and polarization. So to just trace that a little bit, what happened during George W. Bush's presidency in 2002-2003 was Democrats basically then decided to try to use the filibuster. And the most important time that happened, I think, was with a circuit nominee named Miguel Estrada, who was well qualified but relatively conservative, and Democrats were afraid that he would then be elevated to the Supreme Court. At least that's what Republicans say. It's not clear what Democrats actually thought. But in any event, that decision ended up changing the dynamic. So Republicans then, when Obama was the winner of the election, then used the filibuster. And that's, going forward has been an issue. So it means that basically in the Senate you need 60 votes to confirm a nominee, and so that becomes very difficult for whoever the majority is, because often the Democrats and Republicans are pretty evenly split in the Senate. And so that has, I think, changed substantially the dynamics that we see. So just to carry that on, in 2012, what happened was that GOP senators refused to allow votes on 3 well-qualified D.C. circuit nominees whom Obama had chosen. So at that point, Senator Harry Reid, who was the majority leader, basically released the nuclear option, which allowed the nominees to have votes, and they could confirm people with 50 votes, and that has carried forward since that point in time, especially at the circuit court level. Even though we still have situations where you need a majority to confirm somebody to the Supreme Court. So that is what happened. Then to carry that on through, the GOP captured in 2014 a Senate majority in the elections. And so the last 2 years of Obama's term, Senator McConnell, who was the GOP majority leader, basically said that they were going to, didn't say it, but refused to move Obama's nominees at the district and especially at the appellate level. And so he was able to confirm the fewest number of judges at that level since Harry Truman's administration. And so that was a pretty low point for some people. And of course, Merrick Garland, who was nominated by Obama, waited 11 months after Justice Scalia died for any process, which he never received. And so Democrats were not happy with that situation because they thought that was unprecedented. And so that contributed to some contention. So then that development and Trump's 2017 election meant that the GOP could fill something like 108 or 110 vacancies at the lower court level. And they took advantage of that. And especially at the circuit court level, where I think some 18 new judges were appointed in the Trump 1.0, and often over the, in fact, over the rejection of the home state senators, which had been the tradition, which is called the circuit exception to the normal process, which Senator Grassley, who was chair of Judiciary Committee, created in 2017 in order to facilitate the confirmation of those judges, especially in blue states. So a lot of what is going on now is blue state, red state kind of contention in the nomination and confirmation process. I should say, and I haven't said that, both for the appeals courts and for the district courts, home state senators play a pretty substantial role, at least traditionally, so that most nominees do not go forward if they don't have the consent or agreement of the home state senators. So for example, recent example, you could see in Virginia, and this is changing a little bit, and a little bit of an introduction to the attorney, U.S. attorney talk that I'll give in a little bit with Hank Chambers. The senators do recommend as well the U.S. attorneys, and they had recommended 2 people for the Western District of Virginia for U.S. attorney. And the White House did take one of those people, and then he resigned, and then the second person moved into that position. But the senators, felt bound by their recommendation, and so they, I think, so far have agreed to allow that to go forward. But in any event, senators have blue slips, which you may have heard of, which allow them to veto somebody from the home state whom they don't support. And so that gives the senators some authority. It makes sense in a way because they are responsible for the judges who sit in their districts or on their appeals courts or their U.S. attorneys, and gives them substantial say-so in terms of recommending. And they can block if they wish, which they do when there's someone who hasn't met their criteria. So in looking at the traditional process and what that looks like, I just want to talk about that for a minute. So in any event, just to continue the history, Biden, when elected, kept the promise basically that he made about the federal courts being out of whack. In October of 2020, running against Trump, he said that he pledged to return balance, as he said, to the federal courts, and Biden did keep that promise by nominating and confirming 45 well-qualified, diverse circuit judges and 187 similar district judges. I didn't say, but I will say now, that in the period from 2017 to 2020, on Trump 1.0, he confirmed 3 conservative justices, Neil Gorsuch, Brett Kavanaugh, and Amy Coney Barrett. And at the appellate level, he confirmed 54 quite conservative appellate judges, and district level, rather similar district judges, 174. So in Biden's term, he kept his promise, nominated and confirmed 45 well-qualified, diverse circuit judges, 187 similar district judges. And then when Trump was reelected, he in 2.0 has nominated and confirmed a number of people. So 6 ideological conservative circuit judges and about 28 similar district judges, and there are a number of nominees in the pipeline who will be confirmed as we go forward. So then let me talk a little bit about the nomination and confirmation process. Vacancy arises. The White House Counsel and Department of Justice Office of Legal Policy consult with home state senators, attempt to reach agreement on the best candidate. Both offices vet the candidates. President nominates, sends the paperwork to the Senate Judiciary Committee, where the GOP and Democratic staffs assess the nominee, who answers an extensive questionnaire regarding all that the nominee has done since college. Then the staff sets a hearing date. At the hearing, senators introduce the nominee to the Judiciary Committee members. Nominees make an opening statement, introduce their families and friends, and answer questions from all members of the committee who want to ask them in 5-minute rounds, which is not a lot of time. After the hearing, there will be an executive business meeting or markup where members discuss the nominee's qualifications and vote. If a majority votes yes, the nominee goes to the floor where there's a debate on the nominee and a cloture vote to end debate, which needs a majority vote. After that, the Senate votes and the nominee needs a majority to be confirmed. In Trump 2.0, most votes are party line, which means all Democrats vote no and all Republicans vote yes, both in committee and then on the floor, which represents how the process has degenerated, if you will, or just has become increasingly partisan. So, do you have questions? I'll be on with Professor Chambers in a minute, but I'm happy to answer questions if you have them. Yes.
Hello, I'm David. Thanks for your talk. How did we get to our strange, unique Virginia system for judicial selection? Do you know the history of that?
I don't, but I think it's been in the Constitution for a long time. Some of you may have heard Professor Howard, who wrote the revised Constitution in 1969, 1970, talk. And I think it's been carried forward. It does have the democratic notion of you elected your delegates and senators, and so it's just, and it works reasonably well. But as I said, I think vast majority of states do elect, and I don't think it's likely to change, though it could be improved. It could have a little bit more rigorous hearings like the Senate, U.S. Senate does. But I think it has brought forth generally very good candidates, because you have the same dynamic. The home state delegation is going to be blamed if you choose judges who aren't very good for some reason or another, or unethical. It's hardly ever that you hear of ethical problems in the judiciary here, and because I think the judges tend to be fine public servants generally.
Just to follow up on that, so what are your thoughts of how Virginia does it versus the election process the majority of the states seem to have?
I'm sorry,
So, I mean, in Virginia, it's done through the legislature, but in many states, it's an election process.
Yes.
Basically, so what are your thoughts of the two different types of systems?
Well, I think, as I said before, the election of judges by the people is more democratic. But I am concerned, and I think many are, about the amount of money that flows into the states that have that. And so maybe a solution is to be more restrictive about the donations, perhaps. So I don't know. I mean, I think there's a lot of debate about that, but you can see that Virginia's in a very small minority, and I think the vast majority do have elections, and it does have the benefit of letting people have their say-so. But I would hope that they could limit campaign financing, but that's very difficult to do. So. Yes. Sir.
Thank you. Professor Tobias, you mentioned that there are hardly ever ethical issues that arise within Virginia's judiciary. Do you hear comparatively more of those types of issues come out of states that do have elected judiciaries?
That's a good question. I don't know what the numbers would look like, but there are occasional situations like that that do arise, but it's hard to pinpoint them and show that, right? I mean, people don't, use bribery, for example, with judges in any kind of open way, if that were to happen. I think the difficult issues are just ethical ones where there's the appearance of some kind of conflict. And that's where I think the federal system is pretty good, because under 28 U.S.C. 455, it talks about even appearances enough. And I think the federal judges are pretty rigorous about that. They don't get close to the line if they can help themselves. So maybe that's what a state would need, is something, a code of conduct like that. But I don't hear much, and 25 years or so here, and when I was growing up here, I don't remember anything that's like a scandal in the state judiciary. So I don't know what that means, except that maybe the judges are honest and they're, dedicated public servants. I'd like to think that. So.
Can you comment at all on the recusal rate at the Supreme Court level? I have the sense that they are declining, but maybe that's just an impression from media, or just like your sense of when justices are recusing or when they're not recusing.
That's a very good question. I think certainly Democrats have raised those kinds of questions about some of the presently sitting justices. There's some improvement. I mean, there is now some kind of code of conduct, but I think people feel, at least it should be more rigorous. And they're not entirely comfortable with the justices policing themselves. And I can read the paper like you do, and I see things that trouble me. So, yes. Not to mention the present administration. So. Other questions? I'll be back for more with Professor Chambers, who's a lot smarter and funnier than I am.
Thank you very much, Professor Tobias. We'll have a break before our next panel begins. So if you need to step out, get some refreshments, we'll be right back with Professor Tobias and Professor Chambers. All right, I think we are ready to reconvene for our next panel about current topics affecting trust in the courts at the federal level. This panel will be moderated by Professor Price. He is an expert in civil rights litigation, but he also teaches in other areas, including civil procedure here at the law school. And without further ado, Professor Price.
Thank you very much for the introduction, and thank you all for being here. It's great to be here on a nice, I guess it's a spring day. It's just ticked over into spring, and the weather's nice. It's great to be here with my colleagues as well, especially Carl Tobias and Hank Chambers, our esteemed and also cherished colleagues. I'll give a brief introduction. Both of them have done a ton of scholarly work, but also teaching work and contributions to the law school. Carl's expertise is more in federal judicial appointments and the federal judiciary more generally. You heard from him a minute ago, so you know that probably already. My colleague, Professor Chambers' expertise is in criminal law, constitutional law. He's really been focused a lot on voting rights as of late, and he has other areas of expertise that he might share with us that are relevant to our discussion today. So it's great to have them both. I guess I'd like to open up the discussion with something very broad, and we'll see where it leads us. This is a panel on trust in the federal judiciary, and so my question is, for whoever would like to start, what's your sense of the public's trust in the federal judiciary? And you could focus on district courts as compared to the Supreme Court, or any version in between.
You want to jump in?
No, go ahead.
Sure. I'm not sure, and here's part of what I mean. I suspect if we talk to regular people out on the street and said, federal courts, what do you think about them? They may say, I really don't think about them at all. It's just not something I do. Okay. So if we talk to people, though, who do think about federal courts, kind of, sort of, in the public, is there trust? I don't know. Certainly if we talk about Apex, U.S. Supreme Court, I think there are people who have questions. And the questions or concerns I think they have go with the nomination and appointments process. But a lot of those questions have existed for a long time. But they also have concerns in part because of the way, and this is not a knock on our current president, but it's the way our current president talks about judges. My judges. Fella, they're not your judges. Right? And even if they happen to decide a case in your favor, they're not your judges. So I think part of what we run into is that if you think about what the president says about judges and justices, that's where we can run into some real issues. And that's where I think people may have some questions, such that even I will on occasion have to tell folks, well, you know, the judges are doing their best, and they're trying to make the right decision, and they're doing it without fear or favor. Now, it may be that their worldview is sufficiently different than your worldview, or maybe sufficiently different from my worldview for me to believe that they've gone in an improper direction, but they're trying to do what's right. And in that vein, I at least, like I say, I try, when I do run into people who have real concerns, I try to get down to what their core concern is. And if it's a 5-minute conversation, usually they leave thinking that I'm just a flack. And I try to explain to them, no, I'm not a flack. I'm a law professor. Like, isn't that the same thing? I'm like, stop it. And then we just go from there. So a long way of saying, one, I don't think most of the public thinks a lot about at least federal district courts and federal courts of appeal. Some people do think a bit about the Supreme Court, and I do think there are trust problems that have more to do with how the president deals with the court than with what the court's actually doing.
Carl?
Well, what I think has been critical since the president came into office is the incredible job that the federal district judges have done when litigation has come to them that challenges the nearly 300 executive orders that have been issued, most of which have been found to be illegal or inappropriate or violate the Constitution or statutes. Doesn't mean that ultimately people are going to win those cases, but they've been incredible. And you can tell how successful they've been by how virulent the attacks have been from the president and the leaders of the Department of Justice. And so I'm encouraged by what the district courts have done in the vast majority of those cases. But that's not the end of the story. So people have to continue to work on that, work on the process, and we'll see what happens in the midterms.
I have some follow-up questions, and there's going to be time for questions at the end according to the schedule. But there's no reason we can't have questions from anyone here at any time. If you've had one of these as a professor, whether you're currently a student or formerly a student, and you want to ask some hard-hitting questions, well, then just raise your hand and speak them out. So don't feel like you have to wait, especially if you have a response, a comment, or a question based on what anyone just said. So, the message that I think both of you are hitting on is that the trust in the judiciary depends to some extent on whether or not we view the judiciary as, or the decisions themselves as, tinged with or aligned with or connected to political concerns or messages. On that note, we often see or at least discuss the potential phenomenon of someone auditioning for the Supreme Court. So we sometimes see what strike us as outrageous or rather extreme sort of rhetoric from courts, perhaps to get the attention of the current president for elevation to the Supreme Court. I want to ask you about a different type of rhetoric that we seem to be seeing more of, and that's the rhetoric of the district court judge who is in some sense trying to sound the alarm. Here's the opening line of a decision from the Western District of Virginia, district court opinion involving ICE officials wearing masks. It was a challenge to that. And the opening line is, antiseptic judicial rhetoric cannot do justice to what is happening. Right? This is a broad claim that rings true more in an op-ed than in a judicial opinion. I'm not suggesting it's inappropriate in a judicial opinion. This person's probably not auditioning for a higher office in the eyes of our current president. What do we make of this type of district court opinion that we're seeing more of? That reads with more rhetoric than we've seen in the past. Any thoughts?
No.
Sure. It's hard for me to criticize those judges, but of course, I'm a law professor, of course I'm going to criticize. Here's why it's kind of hard for me to criticize. That is, almost any time an opinion gets some press, it's an opportunity to teach. And it's an opportunity for our fellow citizens and non-citizens alike to learn. So when a judge is functionally writing in order to grab your lapels and shake you and to tell you this is law and we're talking about law and we're talking about a derogation of law and I need you to listen and understand and hear me, it's hard for me to criticize because that's what civic education is. And I do a lot of civic education work. On the flip side, of course, we do recognize that judges are supposed to be sober, calm, learning the law, dry, etc. And as a consequence, when judges write opinions like that, you do get a little concerned. Now, when I then get concerned, I then flip back and remember that some folks don't seem to have a problem with, or didn't have a problem with, dear departed Justice Scalia saying stuff like that, even in contexts where he didn't need to. So it's kind of hard to get upset about judges who write like that when many of us were told, I'm not on this side, we're told that Justice Scalia was a great writer. I actually don't think he was a great writer. And that's maybe for a different panel, but I've never thought he was a particularly good writer. He was a smart aleck. I like smart alecks. And I like people being smart alecks, but that doesn't make you a good writer. And it certainly doesn't make you a good craftsman of opinions. So a long way of saying, to the extent that the judge is talking about an issue that does require that you grab folks by the lapel and shake them, I'm okay with that. If it becomes just a way that the judge writes, I can do without that.
Any thoughts? You don't have to have one. I have more questions.
I have plenty of thoughts. There's a piece in the New York Times just 2 days ago raising the very point that you're making. And I think it's a difficult choice that judges make. But a number of them you don't want to chill their speech either. And so it's hard. I mean, I thought one of the most heartening things I saw was when the Western District judge, to remain unnamed, but you probably know who he is, said when the Justice Department sued all 15 Maryland district judges because they wanted to follow the Constitution on habeas issues, he spoke out and just called the president out and said, and this judge is not going to the Fourth Circuit anytime soon, about what the president was doing when he was slandering the district judges and calling them bad people and worse. And we saw what happened with the tariff cases. Even the Supreme Court justices he named are not immune. So that's where I think we are. And so I guess I stand behind my statement. I think that district judges are doing what they can, and the same on appeals sometimes. But it gets harder and harder, I think, because you have to get to majority on 3-judge panels. But we'll see. I mean, I think things have gone reasonably well in our districts, Eastern and Western, and in the Fourth Circuit for litigants. But we'll see.
I'm opening my eyes for questions. Not that you have to have any, but always welcome. So the theme that we've been hitting on so far is, to what degree does judging feel more political these days? And of course, the overarching topic we're focused on is movement lawyering. Let's think about whether or not the political feeling that we have inside some judicial cases is the result of litigant choices, right? We're familiar from the Biden administration, the first Trump administration, and still today, that litigants are acting very strategically in where they bring lawsuits. A lot of the lawsuits challenging some of the Trump policies were brought in Maryland. Deep blue Maryland with lots of blue judges. To what extent are litigants, I won't say to blame, but responsible for this rising feeling that judging is inherently political, even at the district court level? I think we can put aside the Supreme Court, but even at the district court level.
So I'm going to jump in for a second, and because Professor Price is a good friend, he will take this in the spirit that it's given.
Sure.
What do you mean, deep blue judges?
In Maryland?
Yeah.
Well, let's just say it this way, comparatively, right?
But blue in terms of democratic, or are you talking about liberal, or are you talking about?
Well, so the difference between progressivism, liberalism, democratic politics, I don't know. You choose any one, but I'm just going to say, if I'm going to choose among venues, Maryland is more favorable to me if I'm challenging a Trump policy than Texas. I don't care if we call it blue or something else, but yeah.
All fair points. Both Professor Price and I grew up in Maryland, although I'm obviously older than he is. So I know exactly what he means, but what the heck? It's time for a discussion. So we'll go there. Here is part of what I think is going on. I think some people would hear blue and say, who was the president who appointed the person or who nominated the person? Others would hear blue and just say their own worldview. The judge's worldview just happens to be on one side versus the other. But I actually think that those are two different things. I think that the notion, certainly chances are that a president is going to nominate someone who might share their worldview a little more than others. But it's still about worldview as opposed to who the president was who appointed you. It's one of the reasons why when I started, I noted our current president, Trump, and the way he's saying things, because it's not a left-right thing when it comes to talking about my judges. Maybe I wasn't listening, but I have never heard George Bush talk about my judges. I never heard H.W. talk about my judges. I never heard President Reagan talk about my judges. So in terms of that, the identity of the person or the judge with the president, a little different. But that is what can get us to a notion of thinking, well, if you were appointed by a Democratic judge, you're going to go in one direction. If you're appointed by a Republican, you're going to go in a different direction. Okay. That being said, it's actually an important question at the district court level, in part because so many cases end at the district court. I mean, a lot of people think, well, okay, if there's a case, it's going to the Supreme Court. No. Most cases simply don't. And most of them don't even get a real hearing at the circuit court level. So it actually matters quite a bit what individual district court judges who are not sitting on a panel but are making decisions on their own have to say about particular issues. So I do think that it's important for us to think about the idea of judge shopping, where you can go and where you can't go. Certainly there are entire sort of district courts where you might say, okay, that court tends to lean in one direction or another. We all know about the Ninth Circuit and which way it may lean. I think we know it leans in a particular direction because of a lot of other issues that arise. But the pure judge shopping issue that some folks have mentioned in terms of down in Amarillo, for example, with Judge Kaczmarek, that's one where if you have an individual who essentially is in control of the docket based on where the case is brought, that's where you run into judge shopping as such. If you think that judge shopping is a thing and that it works, that's a real problem for trust. Right? If, on the other hand, you say, well, look, judge shopping occurs because it's occurred well before this administration, but it occurs but it doesn't work. If you think it occurs but it doesn't work, then that's a different story. Right? So that's where the trust comes in, and part of it is, this is part of what I mean by the shaking folks by their lapels, is if we are concerned that people believe that judge shopping is going on and that it's working, what do we do in response? And what should judges do in response to make sure that in their opinions they make it clear that this is not judge shopping that worked, this is simply the rule of law. Sometimes that works by just providing a relatively dry opinion on an issue. Not to say it always works, but that tends to be the go-to from my perspective.
Right, and the bottom line is we want judges to decide the cases on the law and the facts, which by and large most judges do. Don't forget the district judges make the record, and so they often are more critical than people think. It's not just the bottom of the hierarchy, but they pick and choose among the facts that are there and are critical to the system.
So it seems like it's possible that movement lawyering, performed well, could erode trust. Actually, we'll turn to a different trust issue, and that's trust between the Supreme Court and the lower courts. I think I'm going to assume that many people on the Supreme Court, at least some of them, probably care about public trust in their institution. They want the people to recognize and respect the court as something that's trying to do something good, that cares about the country's law, and even if there's disagreement with the result in a particular case, there's still a certain minimum level of respect for the result. That's one way of thinking about the trust the Supreme Court cares about. What about the trust that might come from lower court judges? And I'm thinking here of the many times in which lower court judges have, we'll call it complained, we could call it fretted, have sort of thrown up their hands wondering how to deal with what they perceive as a lack of guidance, or even in some cases a lack of respect from the Supreme Court for their own work. Is that a trust that has been changing over time? Is it an area of trust that's really important, or do you have different thoughts?
I'll let Sheldon know this one first. Go ahead, go for it.
No, you go.
Okay. So one of the things that we're required to do when we're thinking about CLE is actually mention a case. And thus far we have not. So it's time for me to mention a case. I'll actually pull out a law review article that happens to have been written by yours truly. And I want us to think about this in terms of how much clarity gets provided. So, all right, there's a case out there, just a couple years old, Brnovich versus Democratic National Committee. And let me just take one step back before we talk about Brnovich for a moment. The question of trust is actually a fascinating question because trust can mean two very different things. Trust can mean I give you signposts because I trust that you're going to make the right decision. Right? Or trust may mean I don't want you to have to go outside of your competence, so I'm going to tell you exactly what you should do. I'm actually not sure which one trial judges want. Do they want specificity from the Supreme Court so they know exactly what they're doing, or do they want signposts because as they're making the record and as they're listening to litigants in front of them, they want to go ahead and be able to think their way through an issue, broadly speaking, and not be told exactly what to do. Why? Because they're smart lawyers too. Every trial court judge is a smart lawyer, and most of them probably think they're smarter than some of the folks on the Supreme Court. They just didn't get their breaks. Right? So in that vein, trust can be a sort of a two-way piece. But here's what I want to note in terms of the Brnovich case. So the Brnovich case is from 2021, and it deals with the standard for determining the legality of time, place, and manner restrictions under Section 2 of the Voting Rights Act. And for some people, their eyes just glazed over. Don't worry about the particulars. Just recognize we're talking about the Voting Rights Act, and we're trying to make sure that people can vote. Right? All of them. Not just some of them, but all of them as best as possible. And there were two provisions at issue. One required that votes be cast in the correct precinct. Okay. And one required one criminalized knowing collection of early ballots by anybody other than a postal worker, an election official, or a voter's caregiver, family member, or household member. Okay. Now, I could talk about this, teach on it, discuss on it for many, many moments, but I'm not going to do that. I should say for many, many hours. I'm not going to do that. But I just want you to know part of what's going on. When we're talking about Section 2, it would be nice to have some specific language, because even in a specific situation, the record can be such that even if you have specific precedent, it's hard to apply it. Okay. So we're thinking, all right, this is what we want. This is what the court did in Brnovich, and they were explicit about it. They said, rather than provide doctrinal rules to govern future cases. Now, this is the quote. This is what I'm suggesting, but don't worry. It's in there. If you don't like it, go back and read it. Trust me. It said, rather than provide doctrinal rules to govern future cases, the court provided principles to help focus future Section 2 inquiries. Okay. What are these principles? 5 principles. 1, the size of a voting regulation's burdens. 2, how far a provision deviates from laws or regulations in effect in 1982, when Section 2 was substantially revised to include its effects test. 3, the size of the provision's effect on minority voters. 4, the general ease of voting in the jurisdiction. And 5, the strength of the state's interest in enacting the provision. Those 5 principles, not explicit doctrines, but just 5 principles, those 5 principles are supposed to be used in some big mushy rule to apply the next time a court sees a time, place, or manner restriction under Section 2. Okay. It's like one of those cooking shows where they give you 5 ingredients and say, make something. And you might make a dessert, or you might make an entree. Same 5 things. Is that trust? Or is that just an abdication of responsibility? In some ways, if you abdicate responsibility, you need to have trust in the people who will now use their discretion to figure out how to apply those principles. Do you trust the district court judges or do you not trust them? Right. In some ways, if I don't trust the district court judges, I might want explicit rules. In other ways, if I do trust the district court judges, I can live with the general principles, particularly if I can also trust that the Supreme Court will listen to the trial court when the trial court, in fact, applies those general principles. Right? There's a lot there, a lot going on, and part of it depends on, unfortunately, who the district court judge is. That is, if we're getting to a point where we're asking, tell me who the district court judge is and I can tell you how they ruled, then we got problems and trust goes out the window. On the flip side, the Supreme Court can help with that somewhat, in theory, by providing reasonable doctrine. Okay. I've said too much. I've talked too much. Sorry. Carl, go for it.
Well, I think it's troubling when the press always tells you this is an Obama appointee or this is a Bush appointee. And I wish we could move beyond that because I don't think those labels help very much. And so I agree with a lot that you're saying. And it also may be a very difficult task to do what I think you're pointing out is a problem. But we do need to have trust in all levels of the judiciary, and we're having issues with that now, to be sure, partly because of the way the current administration works. And so maybe we could talk too about the U.S. Attorney's situation at some point.
On my list, but we got a question. Yeah.
Hi, thank you both for being here. I didn't have the pleasure of having your class, Professor Chambers, when I was here, but I did take Professor Tobias's torts class, my one all year, so it's nice to see faces again and be back. Something that keeps kind of swimming in my mind with this idea of trust the judiciary. I think the reality is we are in a largely politicized and a very kind of polarized political circumstance right now, and I do think it bleeds into the judiciary. Are you seeing, I mean, is there a question of should the role of the judiciary change? I mean, there's this idea of we need independent judiciaries. This is the application of the rule to law, but with, the opinions, not necessarily judges auditioning, but having opinions that lead more into or bleed more into a less dry application of law to facts. I mean, do you see a role changing? Do you see that we need to get back to an independent? I mean, how do you feel that the trust in an independent judiciary is impacted by media calling a judge an Obama appointee, a Trump appointee, talking about a blue judiciary, a blue state, a blue district court? I mean, what is the relationship there? And do you think there is a shift that needs to happen or a reminder to get back to an independent judiciary?
This one. You take this one first.
Well, I think there's the potential to have an independent judiciary, but that depends on the 677 district judges and 179 appellate judges to do that hard work. And it doesn't help that administrations sometimes lean on the judges to come up with the results that they want or blast them after the fact. And I'm particularly concerned about attacks on judges, given what we know in the data about threats of violence to judges, especially in the federal system, but I assume in the state system as well. So,
yeah, the question I think is a particularly important one. All the ones, of course, that get asked are important ones, but this one's particularly important because it can get into the context of the Constitution. That is to say, if we think that the structure of the Constitution is what provides the independence, then arguably they still are independent. That is, if the notion behind life tenure, not decreasing compensation, judges' compensation while they're in office, and those issues are there to guarantee independence, then arguably they are independent. They may not be acting in that manner. Now, it may well be that if we went farther back, we would say, boy, I'm not sure they were ever really independent in the way that we think of. That is to say, if by independent we mean they will make their own judgments, they were always independent. But if by independent we mean that they are in hermetically sealed boxes, that's different. Right? Of course, if we went back to Marbury versus Madison, second case on your bingo card. If we go back to Marbury versus Madison, we think about, well, was John Marshall involved in the specifics of Marbury versus Madison? And a lot of Civ Pro teachers will remind us he was hip deep in the facts of Marbury versus Madison. And no judge today would have failed to recuse him or herself if they were as centrally involved in the specifics that triggered Marbury versus Madison as John Marshall. Yet, it's not like we say, well, you know, Marshall's opinion should be ignored because he should have recused himself. Instead, we just go, bygones. What are you going to do? So in that vein, it may well be that what we ought to do is say, when we mean independent, what we mean is that their opinions will be independent of the person who appointed them. And that's enough. And if it's written in a way that makes us say, we believe that this judge was not unduly influenced or influenced at all by the person who appointed them, great. That's enough. But I think if we think we ought to seal judges off from other folks, that arguably is a different story. And we may never go back to those days, even though I think there are judges who do feel that they ought to be hermetically sealed from lawyers in general, which I think is unfortunate. But I understand why the notion is we don't want any appearances of impropriety, et cetera, and so forth.
Carl, you mentioned this a second ago, what's going on with certain U.S. attorneys' offices. So I want to ask sort of two questions on this. How has certain district courts around the country handled, and have they handled it well, issues with the appointment of U.S. attorneys in particular districts? And then there's a broader, maybe more general question about how have district courts in general dealt with what we might call a more extreme form of lawyering from the Justice Department generally than these judges had normally seen. So there's sort of two things going on there, but they may be related. I know you might have had some thoughts about the U.S. attorney appointments, so if you have some, you can start with that.
Well, you can read my piece, and then you could be at a law review that accepts it. So you're exactly right, and I'll try to do the Reader's Digest version of it. But it also has affected both the Eastern and Western districts here. And to cut to the chase, 28 U.S.C. 546 says that in certain situations, the district judges of a district may fill a vacancy in U.S. attorneys' offices. And 6 or 7 judges have said that what the Justice Department has done in specific districts, including Eastern and Western, and Northern District of New York, and a couple of districts out west, and especially New Jersey, which has been the poster child, that the DOJ has been wrong and actually fired some of the U.S. attorneys appointed by the district judges in some of those jurisdictions. So that's the short of it. The long of it is there are 93 U.S. attorney positions in the country. The tradition was to fill those with people who would serve the whole term of the president. Vacancies do arise sometimes. But, and in the first Trump administration, with bipartisan support, 85 U.S. attorney positions were filled in that way. In this administration, today, there are about a third of those are now appointed properly with a Senate advice and consent, only because of the en bloc procedure that they jury-rigged to make it possible to move them through. They haven't been considered individually. So in the firings, especially in the Eastern District, after 2 minutes or 2 hours after the judges had appointed them, were problematic at best. And so the problem is that this administration doesn't want to provide advice and consent for its nominees. It just wants to be able to pick whoever it wants, which turn out to be loyalists. So that's a real problem, which we haven't ever had, I think, historically with the Justice Department. So that's that story. And hopefully that could be rectified, but we'll see. But so far, the district judges unanimously have ruled in the same way when they've been presented with that issue. Judge Curry from South Carolina ruled on the Eastern District, and others around the country.
Yes, so let's have some clashing structural questions and a little bit of messiness that pops up. Should the Attorney General and should the Department of Justice be independent of the executive branch? For folks who have gone to law school probably in the last decade or so, the question almost sounds silly. Because as we talk more about unitary executive and all that kind of stuff, the notion is simply, well, if the Department of Justice is doing executive stuff and the executive is the head of the executive branch, then the Department of Justice is simply underneath the president. For those of us who went to law school now, for me, so I'm about to go to my 35th law school reunion almost 4 decades ago, the question would have been silly, but arguably in the opposite direction. Because of course the Department of Justice has to be somewhat independent of the president. Why? Because you can't trust the president to do lawful things. So there's going to be a time when there's some sort of independence, and we all understood that. We all understand that the Attorney General is the head of the DOJ, and that the DOJ is an executive department. And that, yes, technically the executive department is under the control of the president. We all understand that. But there's something about the Attorney General and the DOJ and the FBI that suggested that there should be some form of distance between the president and those organs. Indeed, one might argue that when you look at states often divide the Attorney General from the governor. Why? Because you can't trust that governors are always going to do things that are legal. And the last thing you want is for an individual. I'm not dogging out governors and presidents. I really am not. But structurally speaking, we all understand where the incentives are for the executive branch. Right? So as a consequence, we have to worry about whether the entity that also controls justice in the first instance is also under the control of the executive. So that's one of those pieces of the puzzle that we ask. If we think that the Department of Justice and the Attorney General are really to be treated as the President's AG and the President's DOJ, then that has one set of implications. If, on the other hand, we try to treat them as being somewhat separate, recognizing that there's at least dotted line responsibility, that's a little bit different. And that can roll us into the U.S. attorney piece of the puzzle, as well as the question of advice and consent, as well as the question of what is the role of the Office of Legal Counsel in the Department of Justice versus the role of White House counsel, as well as questions of what do we do with prosecutorial discretion? Is prosecutorial discretion an issue for the counsel and for the AG to deal with, or is it an issue for the president to deal with? We also have had this president in particular talk about essentially, I want a case brought against so-and-so. And most DOJ alums just roll their eyes at that.
Or resign,
Yeah, or both, right?
or be fired.
Exactly. And those are things that arise that are a little messy. And again, we're not, this is not a left-right question. It just was a matter that we all just took as true when we went to law school 30 years ago, 20 years ago, et cetera. But the way we think about it now is a little bit different. So if you think about issues regarding the unitary executive and how the Supreme Court seems to be kind of edging in that direction, it has to make you think, well, what does it mean for the role of the DOJ and the Attorney General and the U.S. attorneys moving forward? Are they merely an instrument of the executive branch, or are they supposed to be a little bit separate? Which kind of also makes you think about the prior question about the separation and the independence of the judiciary. So, okay, sorry again, long answer, but there's a lot going on in all of those issues. I mean, I'm lucky, right? That is, I have more, as Bill Clinton would say, I've got more yesterdays than tomorrows, particularly in terms of my career. Y'all who are particularly young, who have to get into this, it's going to be rough, because you're always going to be looking over your shoulder and asking, when will the next executive decide that you are under my control, period, and I will fire you whenever I want? And we haven't even talked about Schedule F. We'll leave that to the side for right now.
This is a related question. Maybe I'm asking you to repeat yourself. Try not to repeat yourself. But to what extent has the Department of Justice, just focusing on them for a second, have they lost trust? How important is trust? They're an advocacy organization, not solely an advocacy organization, right? When we think of, the Southern Poverty Law Center, right? They have their law, that's in their name, right? So they're going to aggressively pursue results in the world that align with their social preferences using the mechanism of law. I know the DOJ is not the same, right? But how important is it for the DOJ to have some level of trust? How does it operate in practice in the courts and in pursuing their ultimate goals, whether for the president or more separately?
Yeah, I'll just be a flat smart aleck on this one. We keep saying DOJ. I certainly say DOJ. They are the Department of Justice. The Department of Justice. You have to trust a Department of Justice. You just don't have a choice. So let me give you an example of what we think of in terms of trust and how we haven't had to think of it for about a dozen years. We'll mention case number 3. Right. Third case we mention is Shelby County versus Holder. Shelby County versus Holder case came out in 2013, where we were dealing with the question of preclearance. Preclearance was an issue that was embedded in, it still technically is, although Justice Roberts killed it, but maimed it, in Shelby County. The idea under the Voting Rights Act is that there are some jurisdictions and some states that have a bad history on voting rights and protecting voting rights. And as a consequence, those jurisdictions, whenever they changed a voting rule, law, or regulation, had to get that law, rule, or regulation pre-cleared before they could actually use it. So they had to ask permission. Some people would say, well, that's not cool. And indeed, much of Shelby County versus Holder was the court saying, that's not cool, but go with me. Who do they have to get permission from? They either had to get permission from a district court in the District of Columbia or the voting rights section at the Department of Justice. Now, that's not to say the Department of Justice always did preclearance properly, but the place where you put the responsibility for preclearance was inside the DOJ, because what better place than inside of the Department of Justice to get a fair read on what effect a voting law, rule, or regulation would have in a jurisdiction? Because we trusted them. Again, not to say they always got it right, but we trusted them. Well, we haven't had to trust them for preclearance for about 13 years since Shelby County. Right? But the notion that we trusted them is the key. And I think we have to have trust because they are the Department of Justice. And if we lose trust in the Department of Justice, I don't know where we're going to go. Right? I really don't.
Well, they say they've served without fear or favor, right? The question is, how are we going to repair the Justice Department?
If there's a new administration, well, there will be a new administration.
Whoa. What are you saying? What are you saying?
There will be a new administration.
Do you have inside information?
Here's my worry, right? There is a new president who's a member of the Democratic Party, appoints an AG that is, favorable on Democratic policies more generally, and there's a big division, like we return to the old days. Won't everything that the Justice Department does in pulling back from some of the policies that Trump has adopted be perceived as political, right? The Justice Department will say, we're only going back to what is normal, and the critics will say, you're playing politics again, right? That's the challenge, as I understand what you're saying, Carl. Am I correct? How do we get past that, or is it just going to take 30 years or more?
It's not going to be easy, and there were a lot of red lines that were crossed. Just ask Comey and Letitia James and other targets.
Right. There will be lapel-shaking moments. One of them, I must say that one of the lapel-shaking, well, I wish it were, but it actually turned out to not be. Just in the past few days, Robert Mueller, former FBI director, passed on. And the response from the president was typically horrific. I shouldn't say typically, that's not fair. No, actually it is fair, but I shouldn't say it anyway. But the response of I'm glad he's dead, it's like, come on, man. Have a little bit of grace. I mean, and he has grace for some people. Right? Mueller was doing his job. Right? Mueller was doing his job. There have been plenty of presidents who have been investigated. It's not clear that the response should be to vilify those who investigate you. The Department of Justice, under new administration, frankly, whether it's a Democratic administration or Republican administration, I suspect will change. And we'll probably get back a little closer to what has historically been the case, which is to say the DOJ has always been somewhat political in that one's vision of justice can be political in some ways. I mean, I think that the Republican Party historically has had one vision of justice that's a little different than the Democratic Party's vision of justice, which is not to say one is better or worse, it's just a little bit different. So I understand the concept that the Department of Justice can be political in some ways, but inside of bounds, right? Essentially, you play it between the 30s on a football field. That's the kind of thing we're talking about, not opening it up to the entire end zone or the entire world. That's just not quite the way you do it. So I suspect that there'll always be some response of, hey, you're changing things, you're being political. But in some ways, we grab people by their lapels and say, hey, we're going back to the way it was when Republicans acted like Republicans, Democrats acted like Democrats, and each side did something stupid, but inside of what we thought of as being the American tradition. Right? And we just have to be honest about it. And in that vein, let me just add one piece of the puzzle. We're in the 250th anniversary year of the Declaration. And like I said, I do a lot of civic education, so I'm required to talk about the Declaration, whether it's relevant to the topic or not. We'll see whether this is relevant. Part of what happened when we thought about the Declaration, when we think about the Declaration, is we declared independence from the country that we were a part of. We're in Virginia, so in 1861, people tried to do the same thing. And some folks said, see, it's just like the Revolutionary War. And the response is, come on, man. It's just different. You may pull away from the motherland under some circumstances and not under others. So grow up and recognize that the American Revolution is different from the Confederacy pulling out of the U.S. Now, I recognize that there are people who have spilled lots of ink saying, no, they're the same. Fine. But let's have that discussion. Let's have a real discussion about whether they're the same or different. And I think 90% of the people would say that they're different. Right? I think that's what we're probably looking at under the next administration, whether Democratic or Republican. Folks are going to pull it back in, because I think there are a small number of people who can get away with what President Trump has gotten away with. And some people would say, hey, and good on President Trump for being able to pull that off. But I think there are a small number of people, and that small number of people may be one.
And I've got a question in my back pocket, but I'm scanning. Go ahead.
So I'm going to push back a little on something you said earlier about picking your court wisely. I understand this idea of neutrality is really nice, but I would say as a movement lawyer, and I'm somebody who's triaged cases for the ACLU for 30 years in Arkansas, we're always looking to get into the Western District of Arkansas, not the Eastern District, where we have one district judge who's definitely auditioning for the Supreme Court with the current administration. And we've got one who is willing to enforce things like the Establishment Clause sitting in the Western District. And if we can, I'm speaking from a law school that's about to hang the 10 Commandments in every classroom. Thank you very much. And we'd much rather be in the Western District, where there would be an affiliated case to a judge who's already ruled it unconstitutional over there. So ethically, as an advocate, don't you have some obligation to be looking at what court, where the potential judges are who are going to rule more favorably to your client, and where does that ethical obligation fit into your notion of a neutral judiciary?
Oh yeah. As a litigant, I think one would be crazy not to go to the place that makes most sense. Now, I think it's reasonable for litigants to also say, look, there may well be some judges who seem to be willing to rule inconsistent with the law over and over again because they've done it once and they'll do it again. And I see no problem with saying, I'm not necessarily shopping for X judge, but I am shopping to avoid Y judge. I got no problem with that. Right? I mean, I think that's 100% ethical, and indeed, running into a fool's errand, I don't think you should waste your client's money in terms of that. But I think there can be a difference, although it's a line. There can be a difference between saying I want that judge and just saying I just want a fair judge. And on that one, I think that's the case. And of course, the ability or the life tenure of federal judges means that you may not be able to duck a judge who you think is not ruling properly in a particular area. You may not be able to duck that judge forever, but I see no problem with trying to. That part doesn't bother me, right? As long as, like I say, the notion is I'm trying to duck a judge who's just not ruling properly and not ruling consistent with the Constitution, as opposed to looking for a specific one who I think is on my side in particular.
Question back there.
This question will require a little bit of fortune telling, but do you all think that the midterms coming up in lots of different states will have any sort of effect more broadly just on like the political pressure cooker that the judiciary is in, or do you foresee like any more specific effects on maybe certain jurisdictions or how the DOJ and lawyers in general are approaching the federal judiciary?
Well, the judicial selection process for sure, if the Democrats capture a majority in the Senate, that will change. And it will look like Mitch McConnell in 2014-15 for the last 2 years. I don't have any doubt about that, if that happens.
Yeah, I'll add just a little bit more. It may depend on what effect there is. As I say, if the Senate were to flip, things get real interesting. If the House flips but the Senate does not, particularly in terms of what messages get sent, then 2027 and 2028, like I say, could look just like what we had in, frankly, in 2019 and 2020. Or the flip side of what we saw in 2015 with stopping any of President Obama's nominees. What would get also interesting is that if one of the houses flips, then I assume that we'll see that many more executive orders. Because the notion is, well, if I can't get it through the legislative process, I'm just going to sign executive orders, and we're going to have that many more. And at that point, the courts may be again called on to think about where the lines are in terms of executive power and non-executive power and issues along those lines. So I think regardless, we're going to be in for an interesting and somewhat bumpy ride, and maybe democracy is supposed to be a bumpy ride. But this one might well be bumpier than in the past. So I think you raised some real good and real interesting questions.
And then the cases are likely to be brought in Maryland and Massachusetts and San Francisco because the appeals courts sit atop the district judges, and if somebody gets it wrong, they'll reverse it. But that's the reality of the court structure as it exists now. And if you flip it, the Republicans will want to be in the Fifth Circuit. So
I think we are at an end, both in terms of time and questions. But I'll close just by thanking our speakers. Thanks so much, Professor Chambers and Professor Tobias, and thank all of you for being here and participating. That's good. Thank you. Sure.
We will recess just briefly while we swap over our panel. We'll see you back here at 11 a.m. Thank you. Thank you so much.
I think we can get started now. Good morning, my name is Sean Maddox. I'm the other symposium editor for this symposium. And for this panel, we'll be speaking about trust in Virginia state courts. So, similar to the previous one, but this one with focus on the state courts. And the panel will discuss trust in state judiciaries with a focus on the Commonwealth of Virginia. This will include the discussion of the Virginia judicial system, the the Virginia General Assembly Senate Court of Justice Committee, and the method of selecting Virginia judges and how it differs from the federal model. The speakers will answer questions related to appearance of impropriety, judicial independence, the impact of terms for appointed judges, and anything else that can come up during the discussion. And here to speak about these topics is first the Honorable William Jarvis. Judge Jarvis graduated from Old Dominion University in 1985 with a BA in philosophy and a BS, or Bachelor of Science, in criminal justice. After doing graduate work for the University of Virginia, Judge Jarvis attended George Mason University School of Law, graduating in 1991. He was a 20-year prosecutor in Pittsylvania County, Pittsylvania County, Virginia, Marion County, Florida, and Prince William County, Virginia, before taking the General District Court bench in Prince William County in 2012. Judge Jarvis was also recently elevated to the bench of the 31st Judicial Circuit in Prince William County. In addition to his duties as a judge, Judge Jarvis is an adjunct professor at George Mason University School of Law. And at the request of the Virginia Supreme Court, he also teaches new and substitute judges Fourth Amendment search and seizure law. He also serves on the board of directors for the criminal law section of the Virginia State Bar, and currently serves on the Judicial Education Committee and Access to Justice Commission Committee on unrepresented litigants. And in addition to Judge Jarvis, we also have Senator R. Craig Deeds. Senator Deeds was originally elected to the Virginia House Delegates in 1991, and then the Senate of Virginia in 2001, where he currently serves as the Courts of Justice Committee. And with that, I think I'll turn it over. I think y'all are done hearing from me, so I'll turn it over to our moderator, Professor Collins.
All right. Good morning, everyone. Thank you for being here, and thank you to the symposium editors for organizing such an interesting day. Carl, why is there's a little bit of should I just? Okay. Thank you so much. All right. Okay. So let's get started. I'm so excited to hear from these esteemed panelists, and we're going to be talking generally about the strengths and drawbacks of the Virginia judicial selection process. But just to get us started, I was hoping you could tell us more details about how judges are selected in Virginia and how this method differs from the federal model we just heard about. I promised I wouldn't cold call, so I'm just going to leave it open.
I'll jump in. Bismarck, the Chancellor of Germany or Prussia in the 1870s, said there are two things you don't want to see made: sausage and laws. Now, as somebody who knows a little bit about doing both, I can tell you that judges are pretty much subject to the same process. There are big differences between the federal and state system. You know, at the federal level, you've got a president who makes appointments, you've got a Senate that confirms, you've got a lot of upfront vetting by bar groups. The state process is much more veiled in what happens, but in the sausage-making process. What we've tried to do the last 10 years or so is make sure that there are vetting processes, particularly for state court appointees. And the process isn't limited to just the Senate. It goes through the Senate and the House. The governor doesn't make any appointments unless they're on an interim basis. If the General Assembly fails to make appointments, or an interim vacancy occurs in a state court or in a circuit court. Vacancies in district court, general district, and juvenile domestic relations, when they occur on an interim basis, the circuit court judges of that circuit have the ability to make interim appointments, but they're all subject to the legislative process. Generally, we try to come to consensus on state court judges after receiving input from different bar groups, but it's essentially just a small group of people in the majority parties, the majority party of each, the House and the Senate, come together and try to figure it out, who's going to be on the state court benches. On the circuit court benches, the decisions are more or less. The House and the Senate have different rules. In the House, the majority rules. In the Senate, the majority of the people in the circuit rules. So even though I'm a Democrat in the majority, there's certain circuits that I've got absolutely no play in. I don't have a voice in those circuits, and because there might be a Republican majority in that circuit. They take the Senate position, and then they have to negotiate with the people in the House to fill vacancies. So there's a lot more sausage making for local judges.
And for those of you who don't know, in Virginia, when you are appointed as a judge by the legislature, General District Court and Juvenile Domestic Relations Court are 6-year terms. Circuit Court are 8-year terms. So every 6 years or every 8 years, depending on which court you're in, you're going to go back through that same process for reappointment. And it used to be sort of like unless you killed somebody, you were probably going to get reappointed. That is not really the rule anymore. Is like there's a pretty responsible process that you have to go through again for reappointment. And I think that's important to know for a couple of reasons, one of which is Virginia is one of the fewest states, a very small number of states that have the judges that are appointed by the legislature. Most states have elected judges. And I do have the perspective of working in both. I was a prosecutor in Florida for some period of time, and they have elected judges. And obviously the bulk of my career has been in Virginia, where they are appointed. And it is a very, very different system, and it creates very different kinds of judges. And so I think that makes a difference, and it's something that I think the public needs to know, because there is some pushes to change the way Virginia does it to maybe elected judges. I just think it's very, very different.
And I didn't mention that. When you're appointed judge at the federal level, it's a lifetime appointment. In Virginia, for the trial benches, it's 6 years. Circuit bench, the other trial bench, is 8 years. For the Court of Appeals, it's 8 years. For the Supreme Court, it's 12 years.
Yeah, that's right.
But we instituted a process beginning in about 2000, I think, that for trial judges that allows some evaluation by lawyers. And you have to. People that are upset about the results of litigation are always going to. Or they're often going to, their evaluations will reflect that measure of their attitude. So you have to look at that with a I guess you have to have some doubt about that process. But you try. At least as one legislator, I want to look at the whole body of the evaluations, because once somebody has given up their law practice to become a judge, that's a significant investment that person's made. And so taking a person off of the bench is something that nobody takes lightly.
Yeah, those judicial evaluations are relatively new in Virginia. How long have they been in place?
Since 2000, 2001, something like that.
Yeah, 2001. And a cross-section of lawyers, court clerks, and court reporters are surveyed every 3 years to see how judges are doing. And as a diagnostic tool for judges, it's ridiculously useful. The controversy about that is that sometimes those evaluations are used to rank order judges at the time of reappointment. And if you were to talk to the folks who do the surveys, VCU, they will tell you that's not the way it should be done. I also think, folks, you got to know is when you go through reappointment, it feels pretty miserable. When you get reappointed, it feels pretty awesome. So I think that that's just the nature of the process. I don't want you to take anything that I say to suggest that the evaluations are not good and shouldn't be used by the legislature to evaluate how judges are doing. It's a difficult process. I do think that the folks who make the decisions take it very, very seriously. And I do think, and the public doesn't know this, those evaluations are public. You can go onto the Supreme Court site and you can find those evaluations for every single judge. You can look at them and see. From a public trust standpoint, not a bad idea.
Well, one of my colleagues, a guy named Scott Servell, who's from Fairfax County, chairs the Senate Courts of Justice Committee, has a habit the last 10 years or so of cataloging all those survey results and producing for us a chart that shows how all the members rank. And he can take it back 10, 12 years. He can he can show you where the rankings, how they hold up against somebody who was evaluated 10 or 12 years ago, or what the person's last evaluation looked like. It is a useful tool, but you have to take it with a grain of salt because, like I said, it's difficult. When there are local judges that are picked, and I'm not assuming that everybody does what I do, but I think that probably that everybody has a similar approach. I want to hear what the local bar associations think about I think they have a pretty good measure of who among their colleagues would be best on the bench, who would, and I try not to let my own personal bias go into situations, but honestly, because I don't know all the lawyers in every community I represent. I want to know what the lawyers in that community think of the people that they've got that are applying for judgeships, and I try to take that all into consideration.
Mm-hmm. I have a couple of follow-up questions. One, Senator, how do potential candidates come to the attention of the legislatures who will be making the ultimate decision? Well,
that's part of the whole. At the federal level, there's a lot more transparency as to what's available and what's not. At the state level, sometimes the lawyers are the first to know because they're going to know when a judge is retiring, and so a lot of people in the community may or may not know. Lawyers I don't know too many shy lawyers, right? If they want to be judges, they know what the phone looks like, or an email, and I hear from a lot of people. And what I normally say to people is, I want to hear from your local bar group. What does your local bar think? Where this judge sits in X county, what do the lawyers in that county think? I want to know I want to know more than just my first impression. Might be a perfectly fine person. I may have had good interactions with them, but I'm one person. I want to know what other people think.
And just to weigh in on that, when a vacancy occurs, as Senator Deed says, lawyers are going to kind of be proactive about trying to figure out what they need to do to put their name in the hat, so to speak. But there's typically in every jurisdiction there's going to be an application that you fill out, and it's pretty comprehensive in terms of like what you've done throughout your career. That application is then going to be given to whoever the members are of your local delegation in the House and the Senate. That application will also be given to the Bar Association. So there will be a Bar Association vote as to who they're recommending. And that recommended choice, and sometimes it's more than one choice, it could be rank ordered 1 through 3. Those choices will then be sent to the local delegation for the House and Senate. They then will conduct their own interviews and their own investigation. They will then decide who they're going to invite to come to Richmond and go before the joint House and Senate Courts of Justice, where that sort of questioning process occurs again, but with a broader group of members of the House and Senate. And then assuming that you sort of cross that hurdle, it's at that point that they certify your name to go to the floor of both the House and the Senate for a full vote on whether or not you're going to be selected.
Thank you. That was really helpful. And I wanted to spend just a few more minutes talking about the reappointment process, because it sounds like it's a very important part of this piece, especially as we're going to start to talk about how the process for selecting and maintaining judges does or does not implicate issues of trust of the broader public. So could you tell me a little bit more about what the reappointment process, what are folks looking for, what makes it feel so kind of perhaps intimidating is not the right word, but like uncertain. And you also mentioned, Judge, that you have learned things about the evaluations that you've gone through, and what do you learn through this process, and how does it affect how you judge?
So the evaluations are, again, I don't want to be perceived as saying that they're a bad idea. I think personally, in terms of like getting it and looking at it and thinking about it, even if I think that some of the respondents are not correct, I think it triggers introspection in a way that I think is super valuable for judges, where you're going to walk around and think, well, someone said that I'm impatient. Well, I don't think I'm impatient. I'm going to ask around and see. In fact, between my initial appointment and my reappointment, I had a federal court judge who is a friend to sneak into court when we were on standing room only, just to watch. And I didn't know he was in the courtroom. He talked to me later on just so he could give me some feedback, so I kind of have some idea as to whether or not that is an issue. We also, in between, at the 3rd year mark, we have a retired judge who will come in and spend several hours and sometimes the full day, where they're going to watch you for the whole day, and they're going to actually do a full written evaluation of you, and they'll sit down with you and they will talk to you about like what they think that you're doing well, what they think you're not doing well. All that super helpful. Where the frustration comes in, as many of you know, because we are type A competitive people, is that I could be scoring very high on a measure, but I'm not going to look at the responses for who responded positively to me. I'm going to look at the negatives. And, out of 120 lawyers, if 2 lawyers says I'm impatient, I'm going to tote that around in my head for weeks at a time. And try to figure out what did I do that made those 2 people angry. Right? I worry about that because there's always the possibility that there's a grain of truth to it. I think statistically there isn't. But that's just not the way we're wired. We're gonna worry about those things. And honestly, I think we should worry about those things. There's always the possibility that there is a grain of truth to it. One of my concerns, if VCU chose to talk to me about it, I would say I don't need to know who the people are, but I do need to know where, like, if a person gives that kind of review, is that a person with 2 years of experience, or is that a person with 12 years of experience? Because that means something different to me if I know that statistic, right? That helps me figure out whether or not this really is a legitimate issue for me. That being said, I still think this is all exactly good stuff. And I think it's really good, again, for those of you there are people who, when you come up for reappointment, it's videotaped and it's live, and you can actually go on the House and Senate legislative sites, and there's a video, and you can watch what's going on. You can watch those interviews. They're incredibly interesting. And the questions that folks ask, especially like if you're doing well and everyone has said you're doing well and you're likely to get reappointed, that's not particularly interesting. The folks who have some struggles, they've scored really low on a particular measure, and see how the folks on House and Senate Courts of Justice ask the questions. Why do you think you had a score that was so low? I think Senator Deeds can answer this, is that I think largely, there's some exceptions, but for the most part, what the legislature is looking for from the judges at reappointment is a recognition that there are things that you need to work on, and a recognition that there is validity in that low score, and that you've actually taken steps to be better about those things.
Bingo. I've been in the legislature a long time. I practiced law even longer, and I can tell you that appointing judges is one of the most serious responsibilities we have in the legislature. You've got to not only ensure the public trust, but you've got to work for justice in the communities that you serve. Back in the 90s, reappointments almost were they were going to happen. Everybody was going to be reappointed. We had a Judicial Inquiry and Review Commission, had a great investigator, a guy named Reno Harp, who ran that thing like a top, and if a judge wasn't doing well, he was gone. He was gone, and the legislature did not have to dirty its hands. Now with the reviews, it's much more complicated for us. What we try to do, what I try to do is look at those reviews and how many people responded. How many people responded? You know, you can't always get the information about the whether it's people with 1 year of experience or 30 years of experience. You can't find that out. But I practiced law long enough to know that there are a lot of lawyers that take a lot of these things personally. You know, you've invested a big significant chunk of your time into a case, and you get a bad result, and you're mad as hell. You know, you want to lash out. So there could be some of that. 2025, I had a judge who had some of the worst scores we've ever seen. And I sat down with him and said, "What's going on here?" He said, "Well, there's just a bunch of liberal lawyers." Well, I started talking to lawyers, and I wasn't just talking to liberals. I was talking to prosecutors. I was talking to people that I didn't represent, people outside of my district, and I found out that there were significant problems, that the survey represented what people were really seeing, and so that guy didn't get reappointed. And like I said, when somebody's given up their law practice to go on the bench, it's a serious matter to take them off. But when they're not doing the job that they're expected to do, and the job, that, to me, it doesn't depend on the result. It depends on making sure everybody's heard, making sure that justice is done in a case, whether it's what I like or not, the result I like or not. It's a serious consideration, but you have to. I think the reviews have changed the whole reappointment process, and still for 95% of the people that are come up for reappointment, it's a clear process. You're going to be reappointed because at most judges who have bad results do say, what can I do to improve? And they take steps, like bringing out other judges and bringing out other people and trying and watching going to different schools, trying to figure out how they can improve their process.
That's right. Before I was a judge, I was a prosecutor, and I was a prosecutor that had a pretty good reputation for being pretty fair with the defense bar. So when I came up initially, I was across the board pretty popular choice. My initial evaluations were there's nothing wrong with them, but they were lower than I expected. And a more experienced judge said to me, "Oh, if you're calling balls and strikes, you've disappointed the prosecutors who thought you were going to be a prosecutor's judge, and you've disappointed the defense bar because they thought you were going to be a defense-oriented judge." So you have to decide, like, what's really going on. And it turned out, and I think it was 100% correct, was that I thought, naively, that if I called balls and strikes accurately, demeanor didn't matter. And then, an older circuit court judge in another jurisdiction literally patted me on the head and said, "Oh, you poor dear. There are three most important things for being a judge: is demeanor, demeanor, and demeanor. How you treat people is a really, really big deal, right? We kind of know that there's two kinds of justice. There's distributive justice and procedural justice. Distributive justice is wins and losses. Procedural justice is like whether or not people get their full day in court. Not just pro se litigants, but how the lawyers are treated in court, right? And I came to realize that you just got to be nice to everybody, sometimes even if they don't deserve it. Sometimes even if they don't deserve it 3 times in a row. Right? And once I sort of realized that and sort of adjusted my general demeanor, my scores soared. It had nothing to do with whether or not I was following the law, calling balls and strikes appropriately. It just was because I was nicer to folks.
Interesting. Oh, sure. We have one right here. Yeah.
Trust in Virginia state courts, and we kind of brushed over originally, how we do it in Virginia differently. I've always been very proud of the fact that Virginia, and even thinking back to law school days 50 years ago, proud of Virginia not electing judges. It seems to me, and we can look in the world, in the political world now, we've had enough trouble within politics. Unfortunately, because I guess the rules and the way the Senate's changed, some of them and whatnot, and the way the game's played, even the Supreme Court, I think, has lost a lot of respect because it sure seems like they're political. As a lawyer, I lost total respect for them back in the Gore decision when they just totally ignored black letter law and issued an injunction against continuing counting when any first-year law student knows the irreparable harm would be stopping counting, not continuing counting, because you can always rule later on, oh, well, that was invalid counting or something, and we're not going to recognize it or whatever, but to stop it. I mean, they just didn't even adhere to black letter law. Ever since then, it seems like the court's been really political. So moving back to Virginia, I kind of wanted your opinions on Virginia staying the way it is and not electing judges, and from Senator Deed's standpoint, how long he's been in it, and I know it might be frustrating, but really your feelings on not electing judges. And the general electorate, clearly even in politics, they don't understand a lot of issues, but something as important as electing judges, their capabilities, etc., I would think the legislature is much more competent to, make good decisions. And then actually the judge could even come in. How would he feel like it was changed and he had to actually run for an office versus going through this process?
Yeah, I went to college in West Virginia and I went to law school in North Carolina, 2 states that elect judges on the ballot. And from my perspective, it's just the wrong approach. West Virginia has a Supreme Court of 3 members. And about 10, 15 years ago, the insurance industry didn't like what they were doing and basically purchased 2 seats through the electoral process. I just don't like the idea of judges being able to having to solicit political contributions and then trying cases that might affect their contributors. I think we have a better approach. I agree with you, and I don't think it's going to change.
Well, I certainly hope it won't change. I think that if it did change and I had to run, A, I would win. But B, I would retire. I wouldn't subject myself to that process. My experience as a prosecutor in Florida, there'd be billboards that would say, I'm going to be moderate. Would suggest like what their judicial philosophy would be without hearing a case. I had a judge in chambers off the record on an issue with the other side present that said, look, at the end of the day, he donates to my campaign. Let's go back to court. Right? This is the same judge that, like, during jury selection, there was an issue as to whether one of the jurors was of American Indian descent, because the defendant was of American Indian descent, and the judge turns to the juror and says, hey, what about that, Chief? Right. So, I'm not a big fan of proof by anecdote, but I just can tell you that from my experience, I don't know whether you folks know this. There's 2 things that you should know. One is University of Richmond School of Law is colloquially known as the School of Judges in Virginia. And the other thing is that across the United States, Virginia judges are thought of as being the best judges in the United States. So I feel like that our process, and I'm not saying that the process is without flaws, but our process is pretty darn good. And if I had to choose between the 2, I would keep it right the way it is.
I want to follow up. I've got to. I've got a colleague that's no longer around, but went to law school here in the 60s, and he couldn't pass a class. I think it was torts. So he spent 6 years at the law school, and after he finished, by the time he came back to the General Assembly, and I'm not going to even mention the year, he was a classmate of something like 85% of the judges. Or he in the state, he'd gone to law school with a huge proportion of the judges of the state.
On that topic, so I can see the real strengths of the Virginia judicial appointment process as compared to elections. Are there any drawbacks or ways that we could strengthen issues of public trust in the judiciary or concerns about perceptions, if not realities, of judicial independence?
What I've seen and what I'm worried about is that too often our process, people love to hate lawyers, right? And there are fewer and fewer lawyers in the legislature. We don't even have enough lawyers to fill up Senate courts of justice. We probably a majority of the Democrats on that committee are, and the Democrats of the majority party are non-lawyers. Non-lawyers picking judges. Too often, I think what I've seen is too often people feel entitled to put their buddies on the bench, and you end up with people. That to me is a drawback. That to me is something I've seen, and I've seen really screw up, and the evaluations bear it out, and I think that's a flaw in our process. I guess it can occur at the federal level too, if the president or the Senate pick the wrong people. But that's certainly a flaw that I've seen play out here.
So for me, the lowest hanging fruit for me would be our judicial evaluation process it surveys lawyers, clerks of court, and court reporters. There's one really big population that they don't survey, and that should be unrepresented litigants. I think that matters as to how judges treat that population. We really don't have a sense of that. When I say we don't have a sense of that, that's not 100% correct. The Supreme Court has created a judicial advisory committee, and that committee has embarked on this mammoth data collection project that is going to be looking at the judicial system in a number of different areas. Judicial performance is one of those areas. And I suspect they're going to come forward with some pretty meaningful suggestions of how we make that process more accurate and more useful to the judges.
Okay. Another topic that influences how jurisdictions choose judges is kind of concerns about having adequate checks and ethical boundaries and reflections and opportunities to correct course if something's going awry. And Virginia judges are bound by the canons of judicial conduct for the state of Virginia, which establishes standards of conduct for judges from the General District Court to the Supreme Court of Virginia. Do you believe that these canons provide an adequate guard for misconduct? And if so, if not, how could they be improved to foster trust with the general public?
That's a really good question. I'm not 100% certain about that. I will tell you, as Senator Deeds will tell you, is that the world of law in a really small jurisdiction is so much different than the world of law, say, in Northern Virginia. In a small, I started off in Pittsylvania County, which is Chatham, which is just north of Danville, Virginia. In those jurisdictions, there's one judge. There's one circuit judge, hopefully sits every day. Sometimes they don't. One general district court judge, one juvenile court judge. Those judges live in that location, and they know every single person that lives there. So rules about appearance of impropriety and ex parte communication. I think ex parte communication is strictly, you can't talk about an individual case, 100%, no problem with that. It is not unusual at all in those small jurisdictions where you see a judge having lunch with a defense attorney on one day and having lunch with a prosecutor on one day. That's just what happens, and no one says anything about it. In Northern Virginia, that is not allowed. Someone will come to you and say, that's a bad look. It's an appearance of impropriety for you to be socializing with one side. I don't think that's correct. But the sensitivity in bigger jurisdictions is so much higher than the sensitivity in smaller jurisdictions. And again, Senator Deeds may weigh in on this when he was talking about the Judicial Inquiry and Review Commission, the JERC commission that really evaluates judges. For a very long period of time, and I think it's generally still the case, is that's meant to be remedial, right? So if there's a complaint against a judge, there's going to be an investigation, and in most instances, they're going to meet with the judge and they're going to say, hey, judge, you know what, that's probably not a good idea. And you probably need to not do that again. And then they're going to send the judge on their happy way and hope that they take it to heart. There is some push, and I think maybe a valid push, to not only take those kinds of violations more seriously, but also to open up those inquiries to the public, so the public can see what's being alleged and can see more clearly how it's being handled and whether or not it's being handled appropriately.
I live in Charlottesville, but I started my practice in Danville, so I've been in those courts in Pennsylvania, but my home is Bath County. And in Bath County, we have a circuit court judge that serves about 4 other counties. He sits in Bath County twice a month.
Yeah.
In Highland County, once a month. So I think the judges that I know take the judicial canons very seriously, and I think they do. Their conduct is, they also understand they've got 12-year terms or 6-year terms or 8-year terms, and they also understand they're subject to these public evaluations, and that we in the legislature take these evaluations very seriously. When I was a young lawyer, the circuit court judge in Bath County had been my Little League football coach. His kids rode horses with my kids. I saw, and the other judges, I still see them on the street or socially, and I don't know. I don't know that the public, out in that world anyway, in Bath and Highland County, everybody knows everybody else anyway, and everybody else knows the judges too. And I think that the judges pretty much have a generally favorable impression with the community. In Charlottesville, where I live now, the judges are more detached from the public, and I don't know that, and generally the impression is tied to a decision they may or may not have made in a particular case, what people read in the paper. I don't know that, and at least the judges I see in court, I'm in court several times a week, the judges all seem to try to do their best to try to be cordial with people and give everybody a chance to be heard.
Great. I'd love to open it up. I'm sure there's a lot of questions in the room.
Thank you, Senator, and thank you, Judge, for being here and answering these questions. Piggybacking on that point, I was a law clerk in a jurisdiction close by, but it was right at a time where I had friends clerking in another jurisdiction, and there was a reappointment that did not happen, and one of the allegations was that there was a certain judge who wasn't giving time to one of the jurisdictions where that judge was supposed to also sit at different points. And it's interesting from the law clerk perspective, it's now interesting from the lawyer perspective, thinking about those evaluations. I've been asked to do them. I do think they're really important. It's a wonderful process to allow some feedback and then take some of it with a grain of salt. From the Senate side, is there an analysis that has shifted, or is there some way that you look at judges who are supposed to sit or circulate throughout multiple jurisdictions rather than something like a Fairfax or a city of Richmond where there's enough going on that they stay in one place? How do you handle those?
Well, I can tell you, I've been in the legislature, been through 35 sessions. And when I was there, when initially there was a lot more representation in those rural localities. With population shifts, there aren't that many representatives anymore. So most of the people in the legislature on the committees, the courts of justice committees, don't have any experience in those little bitty localities, and so they don't ask those questions. It's something, what I've thought about often is that you have a large geographic area within some of the circuits. You've got to make sure that your judges represent all portions of the district, and you've got to look, sometimes you've got to look past a well-qualified candidate to a candidate who might live 60 miles away, who might be able to give those jurisdictions, those rural jurisdictions, more feeling of belonging, and have a better idea of what justice looks like in those communities. So it's something that I think about. I don't know that other people think about it because I just don't know. We as society, think about this. I remember my grandmother bought a set of encyclopedias off a traveling salesman in 1962, or in 1960 census. Virginia had 3.2 million people. We have 8.8 million now.
Right.
We've changed so much that we're just hardly the same place. There aren't as many people that think about. There aren't as many rural lawyers that get elected anymore, and there's not as much consideration of. I don't think of what's going to happen in the rural localities.
Yeah.
It is. It's absolutely an access.
Yeah.
Well, here's the thing, and this used to be just a medical school issue. I thought medical students come out of medical school with $300,000 worth of debt. They've got to go somewhere where they can retire the debt. And there were places, but now it's pretty much the same thing with lawyers. Lexington, a little place I love. Lexington used to be overpopulated with lawyers. Now they've got just a handful. Everybody in rural Virginia is under lawyer to a large extent.
Yeah. So your issue that you've raised, the issue where judge got in trouble because they sat in a jurisdiction where there's more than one county in the judicial district, and this judge would not go to a certain county. That's a pretty rare event. And in most instances, the statistics drive how many cases are in each jurisdiction that then demands judicial attention. And apparently in that situation, the judge just said, I don't care, I'm not going. That's a both unfortunate and ultimately the reason why they didn't get reappointed. That's really rare. That's really rare. You do see some, for those of you who don't know, some judicial districts can have as many as 5 counties. And so you could have judges who within a week are traveling 120, 150 miles to cover all the different courts. My experience in those jurisdictions, the judges are pretty amazing in their ability not only to cover the courts, but also like when they are in one jurisdiction and there's an emergency in the other jurisdiction, that the judge figures out a way to resolve it without saying, I'm not coming to that jurisdiction. They meet halfway with the litigants, figure out something. There are creative ways to solve those problems. What got that judge into trouble was that they were just not willing to budge, to come up with a solution. I do think that is, in terms from a public trust standpoint, pretty important, right? So I think both the litigants, the lawyers, and the public need to understand that, or there should be a perception that we're not interested in being obstructionist, that we want to come up with solutions and we want to solve people's problems. It's part of the reason, like the judges, there's 7 circuit judges in my court, and we meet too frequently. To strive for consistency and to anticipate issues that either the bar or the public might have that we may not have been clear enough about how we're addressing those things, so that we can address those things and try to improve the relative trust. So.
Other questions from the audience?
I have a question, actually, about, so you had talked a little bit about the difference between elected judges, obviously, and appointed judges in Virginia. And I'm curious if you noticed a difference in some of the qualities of those judges based on their appointment system. Just based on my limited experience in a North Carolina courtroom last summer, there appears to be a sort of degree of showmanship, for lack of a better term, from elected judges. And I'm just curious what other qualities you notice that differ.
I mean, you're hitting it. I mean, some judges, depending on the jurisdiction that they're running for re-election on, especially if that re-election is coming relatively soon, you can see changes in behavior on the bench as a result of that. I mean, I found that the judges that we dealt with largely cared less about following the law and more about what they thought the electorate would want from them, which is problematic. Right. The good news is that in the appointed system, that's really not an issue. That's not an issue. The issue for us in the appointed system is the fear, which I think is oftentimes in our heads and not a realistic fear, that the legislature is not going to reappoint us for reasons that are not valid. I think there's a fear of that. As a result of that, I think there is some chilling effect on judges in terms of, I think it does have some effect on how judges explain their rulings. They're afraid if I fully explain my ruling, that will be used as ammunition against me at reappointment. I don't know that that's a conscious thing. I think it may be an unconscious thing where judges are now less likely to fully explain their rulings because they're afraid that they're going to be used against them.
Now, my experience in other states is not really, but it's only federal courts where the judges are not elected. So I don't have any personal experience with state court in other states.
Other questions? Oh, Monica, back for.
Keep chatting. Fun fact, I took the bar right as the Court of Appeals changed to an appeal as of right rather than some of the certification and the requirements regarding what their jurisdiction entailed. So I am curious, have you seen a change in, so the chilling effect that Judge Jarvis just brought up made me think, has there been any impact or any correlation between how judges are giving rulings from the appeals potential perspective? And have you seen that in any way impact their rulings and then also the concerns of reappointment?
I don't know that process has changed for long enough for us to be able to know whether that is doing it. About the same time, we also have a lot more members of the Court of Appeals. And for those of you who don't know, for a long period of time, Court of Appeals, within the Court of Appeals, were pretty consistent. And that's not the case anymore. I'm not saying that's a bad thing. There are dissenting voices now in the Court of Appeals that didn't exist before. Creates a lot more interesting reading from what we used to get. And you have some of the same dynamic in the Supreme Court, but I'm not quite, and maybe Senator Deeds can weigh in on that. I don't know that I have been able to see any change in what appellate issues or what's being appealed based on maybe some perceived change of behavior in the circuit court.
I can't answer that question either, though. I was thinking about a conversation I had with Liz Lacy about 30-some years ago. She was, at that time, an associate justice on the Supreme Court, and we were arguing about the Court of Appeals because when I came to the bar, the Court of Appeals was brand new. I wasn't convinced at that time that the Court of Appeals was such a great idea. And she said, well, no, it does two things. Creates all this new law, and it takes the burden off the Supreme Court. But the Supreme Court's workload continued to climb, and the law, there were rules within the Court of Appeals that one panel wasn't binding on the other. So I think now, with the expansion of the Court of Appeals, you have seen the workload of the Supreme Court go down, and you've seen a lot of new law out of it. I think it's probably too early to tell what impact it's having on the behavior of trial judges, but we'll see.
I will say that when I teach newly appointed judges search and seizure law, there are some cases that come down from the Court of Appeals that are contrary to precedent. And so now I'm kind of like, okay, so this just came out. You need to know it exists. But I also suggest that you hold on. Because there's a fairly decent chance that there's going to be an en banc, or it's going to go to the Supreme Court. And so you just need to know it's there, and then pay attention to what's going on.
Interesting. We're just about at time, but I wanted to, in conclusion, kind of just look to the future and offer you each a chance to offer some remarks on what you would, kind of what you see as the future for the trust in the judiciary in Virginia. What changes, if any, would you make to either the process of judicial selection or reappointment or evaluation? Just kind of what does the future, if you are in charge of the future, what does it hold?
And nobody's got a crystal ball, or there's no perfect process. But as I said a little bit ago, the selecting judges is one of the most important tasks we in the General Assembly have. In the 90s, efforts were made by both Republican legislators and Democratic legislators to create a merit-based system that would provide more objective information with respect to appointment of judges. And that process, I think the time is ripe for a more formalized merit-based process. What I try to do, I try to look at merit. That's what I'm looking for when I'm talking, not specifically to candidates, but to bars, to find out what other people think about this person. Because I know what they're going to tell me, what I ought to think about them, what I know what the candidate's going to say, but I want to know what people they've had experience with say. I think we can have a more formalized process. And I've introduced legislation as recently as probably 2012, which I realize was a long time ago now. But I think that we could still do something like that. A more merit-based process would provide more transparency and perhaps more public satisfaction. As it is now, even though our hearings aren't open, are public, we only have a few people show up for them, and the people that want to speak are basically the same people that want to speak about the judges. They want to basically make the same arguments about every judge in the state. So my sense is there's not a lot of, if the public were really dissatisfied, they'd show up. But a few people show up and they make the same arguments about the same judges. I think we can still do better.
Virginia is relatively recently one of the few states that has really made a push to look at access to justice. And between the Access to Justice Commission and then also the Judicial Advisory Committee that's collecting all this data, we have very serious stakeholders looking at everything in the judicial system. And I would just say, stay tuned. I'm pretty optimistic that those two entities are going to recommend a number of changes to the system that is going to improve public trust. Last thing about that is that I think there's a big difference between litigants and lawyers' trust and the public trust. Public, as Senator Deed says, the reason why they don't show up for the judicial evaluations, A, they don't really know that they exist. You have to go look for it because you care. There's no one out there advocating the public to care. And then so as a result of that, the public gets the vast majority of their understanding of our system from social media or other forms of the media, which, as Senator Dietz will tell you, and most anyone here who has been involved in any case that's in court, is that you'll go and read about the case that you were involved in, you'll like, this reads like some other case. It doesn't, what actually happened in court is not what is being described in the media. So that's an issue in and of itself.
Great. Well, thank you. Please join me in thanking the panelists and the great discussion.
Okay, welcome back everyone. I hope you had a nice lunch hour. We're going to move on to our next panel, and our moderator will be the lovely Professor Tara Casey. She is the director of the Carico Center for Pro Bono and Public Service at Richmond Law, and she has graciously stepped in for us today last minute, so thank you very much.
And if Professor Silva is watching this remotely, I hope you feel better. Thank you all so much for joining, and I want to also extend my gratitude to Fuller for putting together this amazing program all day today. Movement lawyering is not a new concept, but I think that it is one that people have become more familiar with in terms of a term, and how can, especially the interconnection between things like community organizing and public advocacy can work hand in hand with each other. And when Professor Silva shared with me who was going to be part of this panel today, I immediately just thought to myself, well, that's the greatest hits. You really are going to get to hear from not only the people who are writing about this and thinking about this, but also the people who are doing this. And that is truly something that is beneficial for all who are here. So the panel will discuss movement lawyering from the perspective of the legal careers of our panelists. And I would like just to go down the line and introduce our wonderful panelists. I have questions that I will be asking. They also have remarks that they have prepared to share. But we are going to have time at the end for questions from the audience as well. So as much as you can try to remember what your question may be, get those pens ready. If your mind's like mine, that's Swiss cheese. It'll be helpful because as much as you can reduce your question to writing, the more your ears and your mind will be opened up to then what they will be sharing. So right next to me is the fantastic Professor Teresa Viner, who was appointed as Bowen's first permanent female dean and served in that role for 5 years. We know something about first female deans here at the University of Richmond. She served in that role for 5 years before returning to the faculty in 2023. She has also served as the law school's Associate Dean of Faculty Development and as the Associate Dean for Academic Affairs. She focuses her teaching on civil procedure, con law, gender in the law, and other subjects, and her research has been focused on civil rights and how those rights are furthered or thwarted in our adjudication process. So thank you very much for joining us today. To her left is David Tissell, and David is the Pro Bono Fellow at Hunton, which was previously Hunton Andrews Kurth, which was previously Hunton and Williams, and so now it's just Hunton. David is the Pro Bono Fellow with over 6 years of experience in affordable housing program and landlord-tenant law. He brings truly a critical and comparative perspective to the housing law process. Through his role as a fellow, he represents tenants who are facing eviction and other housing issues in the Richmond area. And if people are not aware, Richmond at one point was the second highest jurisdiction for evictions in the country, right behind North Charleston. So for somebody to be engaged in eviction law in Richmond means they are truly in the trenches and the cutting edge both at the same time. His fellowship is in a partnership with Central Virginia Legal Aid Society and the George Hedrick Community Law Center in Church Hill. So thank you so much, David, for joining us as well. Mary Bauer is one of my favorite people on the planet because Mary Bauer I first met actually before I decided to go to law school. And so for whatever flowed from that decision, Mary, you may have some culpability that has resulted. Mary Bauer has served as, and honestly, if you ever heard anybody describe Mary Bauer, the descriptor would be Mary Bauer is a force. And so it is so wonderful that you all are going to have the time in this place in the universe with Mary Bauer. Mary Bauer has served as Executive Director of the ACLU of Virginia since June 2021. Prior to that, she served as Executive Director at the Legal Aid Justice Center in Charlottesville, Virginia for 5 years. Charlottesville was its flagship office, but it had LAJC has offices in Richmond, in Petersburg, and Falls Church, truly aiming toward a statewide civil rights mindset. She also served as Director of Advocacy at LAJC and Deputy Legal Director at the Southern Poverty Law Center in Montgomery, Alabama. Her legal career began as a Skadden Fellow representing migrant farm workers in Virginia, and she has been a civil rights lawyer for over 30 years, litigating a wide variety of cases. As an expert in immigrant rights, she's testified before Congress on multiple occasions, and she's written several groundbreaking reports that others have relied upon in their impact litigation. Mary, thank you so much for joining us. So what I would like to do is to go ahead and get started, honestly, with Professor Beiner, for you to share with us a little bit about your perspective regarding movement lawyering. And how does it look like from your perspective, especially in the different phases of your career? How has it evolved?
Okay, so yeah, my students always tell me that I'm not loud enough, so hopefully you all can hear me fine. Let me begin by thanking you for that lovely introduction. And thank you to the Richmond Public Interest Law Review for inviting me here, and the Sarahs and Sean. I was wondering who Sean was. Okay, thank you all for organizing this and bringing me to Virginia, where I also spent some time during my undergraduate years. So my perspective comes from sexual harassment law. I am very late into the advocacy aspect of addressing sexual harassment law. I really didn't come into it until into the 1990s. So I'm going to give you a little bit of a historical perspective on this, because the development of sexual harassment law really brings together advocacy as well as legal theory. It's like the classic case of both going on at the same time. As a law professor, it really, for me, it ends up being I'm creating theory that hopefully lawyers who are those advocates will be using in their cases. So far, I show up in dissents for the most part, but that's okay. Okay, you got to start somewhere. So if you look back into Civil Rights Act of 1964, which is what sexual harassment is actionable under, you go back to the late 60s, early 70s, nobody was successful bringing sexual harassment claims. It was often women of color, working class women who were saying we're being harassed, and judges were like, oh, it's a personal problem. That's not a term or condition of employment that Title VII was aimed at. And it was really from advocacy work of women at actually Cornell University. There was a very prominent case of sexual harassment there by an directed at an administrative assistant in the mid-1970s. And a bunch of women who were feminist activists there were like, this is outrageous that nothing's being done. And they began to advocate and think about, okay, how can we get at this politically and legally? By 1977, one of those women, Lynn Farley, writes a book called Sexual Shakedown, and basically describes what women are experiencing in the workplace when it comes to sexual harassment. So 1 year later, enter Catherine McKinnon, a law professor, and I think she's got a PhD in political science, and she writes a book called Sexual Harassment of Working Women that creates a legal theory that allows for sexual harassment to be recognized as a type of sex discrimination under Title VII. So we've got advocates and we've got legal theorists sort of working in tandem. And eventually, we get lucky. You get Eleanor Holmes Norton as head of the EEOC in 1980. Thank you, Jimmy Carter. And she promulgates guidelines that encompass hostile environment as well as quid pro quo sexual harassment. And then eventually, we have a circuit court in 82 that says, yes, this is also a form of sex discrimination. And then the Supreme Court in 1986. Also coming in and saying, yes, hostile environment sexual harassment is a form of sex discrimination actionable under Title VII. But that doesn't come without some setback. Okay, so the court in Meritor, along with recognizing the claim, made it a kind of difficult claim to be successful in. They, for example, Michelle Vinson, who was the plaintiff in that case, they said, well, you can consider her dress and her sexual fantasies in deciding whether she is being sexually harassed or would find this offensive. They didn't set a standard for imputing liability to employers for the harassment by supervisors. They just said, oh, use agency principles, whatever those might be. And they also created an unwelcomeness standard. Well, the harassment has to be unwelcome. So, like, who welcomes sexual harassment? This is like, it's oxymoronic, as you might expect. So all of these things led to ways in which lower courts could undermine the sexual harassment claim. And in some instances, it was actually the Supreme Court of the United States that stepped in and said, no, you're getting this wrong. This is actually actionable behavior. They did it in 1993 in Harris versus Forklift Systems, where they said, no, you don't have to have severe psychological distress in order to bring one of these claims. So the lower courts were really using Meritor in some ways to undermine it. And eventually we have the court finally settling on a standard for imputing liability in Eller through Farragher, where basically it ends up that if an employer has a anti-harassment policy and a little bit of training and a way for people to complain, they can pretty much wiggle out a liability for sexual harassment. And this is where I enter. Okay, so I'm now a legal scholar. I did practice law for 4 years. And I start looking at sexual harassment law, mostly because I couldn't figure out what was sexually harassing. I would look at what was happening in these cases, and judges were dismissing them out. Not severe or pervasive enough, not severe. Summary judgment. Sometimes directing verdicts after jurors found that indeed this was sexually harassing. Overturning jury verdicts. And I was like, this is actually partly why I ended up doing judicial work, is I was like, well, who are these judges? Who are the people deciding these cases? And that led me to Carl Tobias and a whole bunch of other people who do judicial stuff to try to take a hard look at the judiciary and why these folks were not finding things sexually harassing that I thought were sexually harassing. It also led me to the work of psychologists, behavioral psychologists who were studying how does this workplace phenomenon work. And I discovered a bunch of things. One major thing I found was that, guess what? The stuff I thought sexual harassing was harassing, the majority of Americans thought was sexually harassing as well. It was only federal judges who were not finding things sexually harassing. And there was a lot of talk about, well, who should the reasonable person, because you judge sexual harassment by a reasonable person standard. Who should be the reasonable person? Should it be a reasonable woman? Well, it turns out that there's really not much difference, you'll be surprised by this, between what men and women think is sexually harassing in reality, okay? We all agree, you grab somebody's butt, it's sexually harassing. Guess what? The courts don't think so, okay? We all agree, but the courts do not. So one of my major critiques as a law professor was coming in and saying, they're getting this wrong, okay? They have a reasonable person standard. This is not the reasonable person. Studies show that we have a pretty good consensus on what we think is sexually harassing. The only people who disagree are the federal courts. Okay. Also attack the other Farragher standard. Just in case you're curious, organizational psychologists have found we don't really know what curbs sexual harassment in the workplace in terms of training or what you need to do to somebody, what kinds of punishments will actually be effective in getting somebody to stop sexually harassing who has the proclivity to do so. We do know a couple of things. The good news is we know it's top down. So if the heads of organizations care about that sexual harassment does not occur and that there is consequences and they make it clear, there's much less likely to be sexual harassment in an organization. So there's lots of studies. Usually, actually, the military is well studied because they had tailhook. They had a whole bunch of stuff go on that was really pretty awful stuff. And they found that if whoever the CO was, the commanding officer, took sexual harassment allegations seriously, there was far less sexual harassment of lower-level servicemen or servicewomen in those organizations. So we do know that does seem to have some impact on whether or not folks are sexually harassed. So my real contribution here has been to look at, okay, how do these things really operate in the workplace, and where is the disconnect between the legal standards and what would really be effective in really eliminating sexual harassment in the workplace. All right, so the disappointing part of this is, you all know hashtag Me Too. So we've been doing this a long time. Okay, these feminists started in the mid-1970s. I don't enter in until 20 years after they've done foundational work. After the Anita Hill Thomas Clarence hearings, which we thought, all right, this is it, we're finally going to get it. Guess what? Not so much. We get to 2017 and the hashtag Me Too movement, who knew Alyssa Milano of all people would start it. And we have millions of tweets by women who have been sexually harassed after, of course, a lot's been brought to light by the sexual harassment by Harvey Weinstein. So every time I think we're making some progress, it seems like, no, we haven't made the progress. And the courts are still not doing what they need to do in this area. So I think for those of you who are students interested in movement lawyering, it never stops. I mean, you get some steps forward and you get a few steps back, and then you realize we haven't come close to finishing the business of movement lawyering. So mine is from more of an academic standpoint. I hope to give lawyers, by the way, if any of you do plaintiff sexual harassment law, I've got a book that is like the primer on how we should change it. Anyway, I have all of the theory behind the organizational psych and how you can do it as a legal matter to try to transform the law and move it in the right direction.
Can I ask a follow-up question then in that area before we move on? Is how, because you mentioned the women's civil rights movement really started to take hold the 60s, 70s, and here we are. How do you see that level of community organizing and social movement intersect, overlap with then what's happening over here on the impact litigation and substantive legislative change side? How do they relate to each other?
So I think not as well as they should sometimes, as it would be one of the things I would say. So community organizing was fits and starts in this area of law in particular. So it gained traction in the 70s. There was organizations started that were expressly aimed at politically going after sexual harassment and seeing if we could sort of get some groundwork done in organizations. And those folks started to get defunded. I mean, so you had backlash during the Reagan administration. I mean, Clarence Thomas, as head of the EEOC, argued against Michelle Vinson in Meritor, in the case that established that. So, you have backlash, and a lot of the grassroots stuff sort of fell by the wayside because they couldn't keep their funding when there was pushback by employers about the extent of which sexual harassment was being sort of attacked in workplaces. So let's just say, I think it's fits and starts with the grassroots organizing. I think that with, you'll have some legal theory that'll gain some traction, and then you have backlash again. I think I'd like to see more interaction between the two. I think there are some, in this area, the lawyers are sort of scattered around who are working on it. It isn't as organized as something like the ACLU. Thank goodness for you guys. You guys are nice. I know. It has been sort of a fits and starts kind of between advocacy and the sort of grassroots organizing. I'm sort of, when I was writing, I wrote a chapter on this history, by the way, and they asked me, well, what about Me Too? And I was like, I've seen this before. It's going to be a flash in the pan. It's going to be exciting. Everybody's going to be excited, and then it's going to head south. And it has. I mean, we have a president who's been found liable for sexual assault, and he's still the president. So some of this stuff is still there.
It needs more than a hashtag.
It needs more than a hashtag. It needs more of a concerted effort. I think we need sort of a joint group of lawyers who are interested in this and legal scholars and legal theorists to actually get together and work on it. And I don't think there has been that sort of cross-pollination. Yeah.
Mm-hmm. Possibly with the advent of spring, some pollination can happen here.
I would like that. I would like that.
David, to pivot a little bit now in the area that you're working in, because as I mentioned before, you're both in the trenches as a litigator, but also through your role as a pro bono fellow, that is all about being embedded in the community to work as an advocate. Could you describe a little bit about, I guess, what brought you to be a pro bono fellow and how being a pro bono fellow for Hutton has engaged that type of community-based lawyering? Sure.
First of all, thanks so much for having me here. I'm very humbled to be here, particularly on this panel. So what I do primarily is legal aid work. Legal aid is providing civil legal assistance to low-income people. So civil meaning not criminal. And in the civil realm, there's no right to counsel. So there's a gigantic gap between the need and the actual provision of legal services, whether it's advice or full representation. And a lot of people know that, but just putting it out there to make sure that we're all starting from the same standpoint here, that there is a need for more attorneys to be assisting low-income people with their civil needs. So Hunton, which is the firm where I work, created a pro bono office in 1990 in order to try to help with that. And it's a little bit unique. We have a neighborhood office in Church Hill that is basically a legal aid office, but it is Hunton. I work for Hunton, which is a international law firm. It's an Am Law 50 firm. We charge our clients $50 if we're going to represent them in a case. That's been the same flat fee since 1990. Hasn't indexed to inflation, which I think is probably good. But minds may differ about whether you should charge anything at all. I don't really know where I stand on that. But we provide assistance with housing, also family law, specifically uncontested no-fault divorces, guardianships, protective orders, and in the housing realm, mostly evictions, but also a lot of cases about conditions, unlawful exclusion, which is basically an unlawful eviction that's occurred, like a lockout. And so legal aid's been around for a long time, since at least the 60s when it really got funded in the war on poverty. And it's been, funding for it has kind of not kept up with inflation also. It's been reduced compared to the need, which is only growing. But legal aid isn't necessarily the same thing as movement lawyering. Movement lawyering, and we can talk about this more, but I think the idea with movement lawyering is you're not just serving the client in front of you, the person, but the other people that are like that person in the same situation and the same. So for example, if I have a client who has a tenant at a certain complex with roaches, they have a bunch of other neighbors that also have roaches. I'm thinking about the other people in that same situation, not just my own client. Although, of course, my client, I have to be their lawyer and get the best outcome for that person. And that's always a little bit of a tension in the whole concept of being like a movement lawyer. So what do? I do legal aid. I try to do movement lawyering when I can. Sometimes I just get routed a case and I have to try to do my best for that client. But I also, a lot of my cases come from organizers. I have a close relationship with organizers at New Virginia Majority, also Legal Aid Justice Center. I have a lot of leeway in which cases I select for full representation. It's like one of my main levers is like, I'm going to work with this person, maybe this other person, I'm just going to give them advice. And these things really, it's a factor in my case acceptance. Like if I work with this person, is this furthering the tenant movement in Richmond? Am I working with this case? Is it really just a one-off? I mean, that's like one of the 5 things I think about. So it's not the whole thing, but it's part of it. I do advocacy and lobbying. A lot of legal aid attorneys cannot do that because the Legal Services Corporation, which is the federal agency that funds legal aid, has a pretty strong restriction against any like lobbying efforts, like trying to influence public policy. Since I work for Hunton, I'm not bound by that, and so I've worked with partner organizations, VPLC, LAJC, and others. That's Legal Aid Justice Center and Virginia Poverty Law Center, on a lot of issues that impact my clients. So like trying to improve law for tenants. Some things have happened this legislative session that I'm excited about, and one of them is not just for tenants. It's making it easier to bring your phone into court if you're not a lawyer. And that's an example of something that someone might not think is a legal aid issue, but like if you're in court every day and you're in line and you're the one that the security guard says, hey, you go this way, and everyone else has to like put their phones in the cubby and everything or bring it back to your car, you know, if you actually care about the people that are your clients and you're thinking about them from a movement lawyering perspective, those are the kind of issues that we also can advocate for. So another thing that I do is teaching and managing attorneys. So since I'm a pro bono fellow at Hunton, I'm cultivating other attorneys to do my cases with me, or then like become a pro bono leader in housing or in family law. And so I'm organizing in a different way in that sense. I have one-on-one meetings with attorneys, talk about like what's important to them, try to find some way to make it that housing is what's important to them. But often it is. You can get there with someone, and you can get them to take a case. And so what the best example or the best way to state what I think I'm trying to do, what we're doing in this program, is providing the best attorneys in Virginia to some of the poorest residents in Richmond and with the toughest poverty law issues. And by doing that, I think that we are changing people's lives, both our clients but also the attorneys, and trying to improve the city through doing that.
Thank you so much, David. I have a follow-up question to ask, because for folks who are not from Richmond or maybe new to Richmond, the Hunton Pro Bono office is in Churchill. It's on West Marshall Street.
Mm-hmm.
And it started in 1990 something.
I think 1990, yeah.
1990. But for the folks who don't know, back in that time, that office was, the neighborhood around it looks a lot different than it does today. Mm-hmm. In terms of the redevelopment development that has occurred in the Churchill neighborhood. But at the time, it truly gave, it was embedded within the community it sought to serve. So from your perspective, how important is an attorney or an organization, how important is it for them to be embedded within the community they are looking to serve, and for both representation, but then also for that large movement lawyering piece?
I think it's really important, and I think the word embedded is good, and it can mean different things. Where is the physical location of your office is maybe like one of 10 ways that you might be embedded. Mm-hmm. I think so much of what I see as like problems in our society right now is like just inequality means that like we're just living in totally different universes in the same city. Like the attorney, not to pick on anyone really, but I'd say like most of the attorneys that are in my law firm are living in a very different Richmond than like my clients are. It's just a totally different place. And there are like no connections between these worlds. And so really what I see my role as is providing more connections, mm-hmm. Bridging social capital between people that like really would never meet otherwise, and teach each other about their own life stories. So yeah, where your office is matters a little bit. I mean, people can walk right up to our office. It's on the ground floor. We also have the big firm tower downtown, and occasionally I have people meet me there for whatever reason, sometimes like to scare opposing counsel in a settlement conference or whatever. But
use what you have.
That email signature goes a long way sometimes. But being embedded, like, I think also means going to meetings with community organizers and other community groups, talking to people like they're people and not like just like your clients or whatever. Like you're having a conversation with someone, and but yeah, that's how I would answer that.
It's interesting that I heard it described as not necessarily that we have a polarized society, is that we have a molecularized society, because we're in all of these different pockets, and it's not necessarily as binary as polarization, but it's more a little bit more unwieldy than that. So this all brings us, Mary, we've also, our two co-panelists have already referenced the work of the ACLU of Virginia, and in many ways y'all are movement lawyering incarnate, because you are pulling together both legislative policy change, systemic change, as well as impact litigation as well. And what do you see as being, how would you describe ACLU and your work as being held up as the example of movement lawyering and the history of movement lawyering in our country?
Yeah, that's a great question, and we talk about this at our office all the time. Like, are we really movement lawyers? And I think there are folks who think we are, and there are folks who think we're not, and because it's a complicated issue. What I would say is that we have, over the last number of years, really changed our approach from thinking about lawsuits to thinking about campaigns, right? And lawsuits are a tool that you use in campaigns. But I think we all have to recognize at this moment in history that the courts alone are not going to save us. It is not enough to file a bunch of lawsuits. And it is like unseemly and embarrassing how much I like to file lawsuits. Like, I think it is just honestly the funnest thing that I have ever heard of. I think it's like awesome. Even when it's not strategic, I feel that way. So I have people around me who are like, we're not suing over this. That's, you're not going to get where you want to get. But I guess what I'm saying is, if your lawsuit is not part of something bigger and more significant, part of some kind of movement, you will lose. You may win, but you will lose. And I thought I would talk about a couple cases I've had that just sort of illustrate that. Back when I was at SPLC, we filed a lawsuit in Mississippi. We were based in Alabama. We knew very few people in Mississippi. SPLC didn't even have a Mississippi office yet. And we sued about this kind of very particular issue related to the Freedom of Information Act. They wouldn't give us documents related to the importation of guest workers into Mississippi, for lack of a better term, basically. People who are coming from other countries to be employed by Mississippi employers. And it's very clear under federal law that that stuff is discoverable. So we took this case and we went to the Mississippi court, and we went to the Mississippi Supreme Court, and we won. And they said, yes, you have to give them these documents. But we had no other connection to that area, to the court, and what we discovered is the next year they just went to the legislature and got the law changed, and they never produced those documents ever again for anybody. And we didn't even know it because we weren't particularly connected to the community. It was kind of this theoretical, like, interesting issue for us. So we lost. We won. We got a great decision from the Mississippi Supreme Court. A year later, it didn't exist, and we never did anything with it again. So that is what I would say a pretty unsuccessful lawsuit, and an example of what happens when lawyers sit in their office and think of things and don't talk to people. And I would contrast that with a case we did basically the next year, which is a lawsuit that we filed in Alabama after they passed a very extreme anti-immigrant bill in 2011, I think it was passed, a law that was referred to as HB 56, that had about 30 provisions making most aspects of an immigrant's life illegal. And that is, it had provisions, for example, that said that undocumented immigrants can't contract, can't rent houses, can't get utilities, can't get water, can't send their children to school, can't do a wide variety of deeply horrific and offensive things that we thought was clearly unconstitutional. And in that case, we took a very, very different approach. We were in Alabama. I was an immigrants' rights lawyer. This was for us like a very high stakes and existential campaign. But we immediately began organizing and spent a lot of money hiring organizers to work in immigrant communities across Alabama. We helped create a group called ACIJ, Alabama Coalition for Immigrant Justice, that was incredibly powerful. We did a ton of work in the legislature to convince some legislators, at any rate, to amend the law, and we filed a lawsuit. But we didn't win the lawsuit initially. We actually lost because, well, we lost initially with the district court. They enjoined one or two of the provisions, but let most of them go forward. And it was really a very terrible year. It was about a year from the time the law was passed to the time the 11th Circuit ultimately enjoined basically every single provision. But along the way, we committed to this as a movement for the rest of, for our work, right? We committed to organizing with people. We committed to bringing people to the legislature every single day. So the legislators had to see that, yes, there are immigrants in Alabama, something people would be like, well, we don't, And we did prevail in that case, and we got some really good decisions. But what I think was much more important is that we really changed the populace in very significant ways. That is, the next years we saw ACIJ and like immigrants lining the hallways of the legislature every day with their red shirts, and really standing up and showing and fighting that they were in it for the long haul. And that, I think, was very powerful. And so I would say, just to think about our civil rights movement in the United States, we didn't win because the Supreme Court found some way in Brown versus the Board of Education. That is not what caused us to win. That was an important tool, maybe a big and important tool, but it was not the primary tool of that movement, and it wouldn't have succeeded, even on as imperfectly as it did, without this sort of larger commitment to being with the humans that are impacted, and standing with them and hearing them and understanding the way that these laws actually work in the real world, and then kind of working with people to figure out all the different sort of pressure points. When we were in Alabama, when we were fighting HB 56, we had a protest every single week, and not a single one of them involved a person who worked at the Southern Poverty Law Center. Like, one week we would have all the farmers come and talk about this, and then we would have church people come and talk about this, and we would have civil rights leaders come and talk about this, and it was very, very powerful. We worked really closely with some of the sort of traditional civil rights leaders in Alabama, and to have, I remember one state senator from Selma who stood up and just gave the most powerful speech at the Alabama Senate, and said, he was a black man, he said, basically, when I was 16, my mother didn't know if I was coming home. Like, that's what my parents lived. That was the civil rights movement in Selma. And that is the same thing that is happening here. And to have him say that, and not me, was incredibly powerful, right, and incredibly important. And that link between the civil rights movement and the fight for immigrants' rights turned out to be so powerful. Now, like, Alabama is still, like, objectively terrible in terms of, like, basically every law that gets passed there. It's at an incredible kind of supermajority. But I do think that the act of coming together with people and bringing all of these tools together and empowering communities and clients, like, we do that deeply imperfectly at the ACLU, because we have a lot of other goals too, right? We have, we want to win our lawsuits and we want to do things, but I think that is the only way to affect real change, is to think beyond the lawsuits as much as we love them, and to really use as many tools as you can. So we have a community organizing department. It's pretty small right now. We're looking at expanding, but trying to kind of figure out what that looks like. Because to be embedded in the communities we serve, we're a statewide organization, we have 30 staff. So we can't be embedded in every community that we serve. There's just not enough capacity to do that. So that's, that looks different depending on kind of what that is. I encourage all of you to sort of, to think about the real change that we want to see. And I tend to think of it in terms of a lawsuit, right? And like, what are the things that, the legal hooks. And the legal hook is often, what I found is that the lawsuit that we bring is not always the exact same thing that the client cares about, right? It may be, that's just where you have a legal hook. And so you're bringing a case that may not be squarely about what the human being wants to talk about. And so, kind of working through those issues and bringing all of these tools, lobbying, litigation, organizing, and for us, one of the most important tools is communications. We have a communications team of 5 out of a staff of 30, and we tell stories. We tell stories about, our clients, about communities, obviously, like, with deep respect for them and their permission. But I do think that's one of the key tools that lawyers have. Is like, we know how to tell stories, and we know people who are, deeply impacted by by harmful policies. So.
Can I ask you a follow-up question?
Yep.
Because in one of your previous lives, as you were talking, it was reminding me of the movement that happened in Virginia to abolish the disenfranchisement of people's voting rights because of felony convictions.
Yep. Mm-hmm.
And during that time, you were involved in both impact litigation as well as legislative policy work simultaneously. So when you were both trying to work with legislators and policy changers and cultivating those relationships to advocate for change, while also at the same time bringing a lawsuit, a class action lawsuit against the state, how do you balance the two when you're doing them together? How does that work?
Oh, that's hard. We're dealing with that right now, actually, right? Because there's a constitutional amendment that is going to be on the ballot in November that we worked very, very hard to get on the ballot. It had to pass the legislature twice, right? All of the stuff about, and it would restore the right to vote to people who were who have convicted of felonies and who have served their time. That's not exactly the constitutional amendment we wanted. We wanted people not to be disenfranchised. There are plenty of states where people are allowed to vote while incarcerated, but that was not what the legislature was prepared to pass. So we've been working on that. We actually have been working on it for a decade because we passed it in 2021 and then the legislature flipped and we couldn't pass it 2 years in a row as you are required to do. So we had to start all over again. So we have that constitutional amendment that all Virginians are going to have the right to vote on in November. Similarly, like a couple years ago, we filed a lawsuit with just this brilliant legal theory that I had absolutely nothing to do with, but it was under something called the Virginia Readmission Act, which was the act that readmitted Virginia into the Union in 1870. And as a condition of admitting Virginia back into the Union in 1870, Virginia had to agree that it would not disenfranchise anyone for something that was not then a felony at common law. In 1870, there were 11 felonies at common law. In 2026, there are well over 2,000 felonies in Virginia. So and as a result of the many felonies in Virginia, that Virginia almost immediately began disenfranchising people for a whole host of new felonies, ignored the law altogether. So we won that lawsuit actually a few months ago. It was like pretty incredible. The court said that all of these folks should not have lost their right to vote and that should be restored. So now we're dealing with this lawsuit and a constitutional amendment, and it's wildly confusing, and the legislators are mad at us because we have brought this lawsuit that is like very confusing, and it's kind of a mess. We're really excited. We think we won this big victory. We think both of these things matter, but it is true that often if you go over to the legislature and say we want to pass this bill and we've got a lawsuit about it, they'll say, nope, we're not touching it until your lawsuit's over. And we're like, there is nothing in the law that requires that approach. That is such a Virginia approach. It is like other states don't do this. They fix things when they're wrong, even if there is a lawsuit pending. So that's a real issue in Virginia, and sort of sorting through those timings and like, do you wait to file your lawsuit and see if you can get a little bit more out of the General Assembly, or kind of how, those are really hard and complicated questions.
Yeah. And it's also the cultivation of relationships. That,
for sure.
Legislative policy work is the long game.
Yeah. We try to have different people doing these things, but that's often not sufficient.
Yeah. So movement lawyering is messy.
Yes.
Okay,
for sure.
that'll be one takeaway.
Hard and messy.
David, going back to you, because this idea of who is the client in movement lawyering, because you were referencing before, is that you're seeing these systemic issues, and sometimes you're representing a class, for housing condition cases and the like, and you see the bigger issue that needs to be solved, but you still, as you described, you have that person in front of you who has legal needs right now. Have you encountered a time when the individual client need may be in conflict with the bigger issue, and in terms of what the outcome might be, and how does an attorney who wants to be engaged in movement lawyering reconcile sometimes those cross interests?
I'm looking at Professor Cassie Powell in the audience because we talk about this a lot in some cases that we've been working on. I've been working with a group at a mobile home park in Chesterfield called Shady Hill that has a lot of issues, to put it mildly, in terms of the things that are happening at the county level with rezoning, and then also just problems on site in terms of utilities and retaliation and tenant harassment. And I represented a lot of people there, and I've taken some losing cases there because every case that we take against this particular owner in some ways increases the power of the residents association, because we have them fighting what should be easy eviction cases. I'm making them do everything, the max, and it drains their resources and it makes them pick their battles, and that helps the group. And so in general, like that's what I was saying before. Like it can come into case selection criteria. If you're working on a specific community campaign with organizers, you might take cases that you're going to lose, and you know that, but there's still reasons to do it. But when you're in one of those cases that you might lose, there might be, or in a case you might win, the individual client might have interests that are contrary to like the tenants association or the residents association. For example, maybe my client might just want to do a move out agreement rather than litigate it to the max or whatever. And if you are a individual's attorney, the bar, the ethics requirements, you have to really put that client individually first. Usually, kind of always, but there's ways that you can do that are not always completely contrary to broader movement goals too. And often these things that seem like they might be contrary, it's actually just like a little bit of a conflict. It's not that big of a conflict. Like if this one person takes a move out agreement, and that doesn't necessarily really defeat the purpose of, at odds with the purposes of the association. And to the extent that there is an actual conflict, like a conflict of interest, sometimes you just need to say, this is a conflict of interest, I can't represent you.
Yeah. I feel like we're coming now full circle, Professor, because we've been hearing about the legal practice, and we've been hearing about legislative policy advocacy, but where we began was scholarship in the judiciary.
Yeah.
And I was wondering if you could describe where you see the role that the academy could possibly play in this space, especially as it not only are the teachers of the judiciary, all of the judges were at some point a student, one of you might be a future honorable, but also in the ongoing conversation that happens within scholarship. Mm-hmm. What do you see as the role that the academy could play then in this movement lawyering movement?
So I think we come up with the theories, although we're watching that Virginia, because we got the same thing in Arkansas. We're watching your Virginia case with the felonies. So we've been talking, I triage cases for the ACLU of Arkansas. So we've been talking about you. Yeah, we've been talking about you guys. Anyway, so it was creative, super creative. So I think the role, and I've only been brought together with a bunch of lawyers who are, working in organizations like the ACLU and legal scholars. I've only been brought together with that whole group working on women's issues once in my entire career. Because and the lawyers who are working on organizations like the Equal Rights Advocates, they do great work in San Francisco on equal rights in the workplace, among other areas. We don't have as much opportunity to get together as we should, but they were very clear, the lawyers who do this work, you need to give us our theories. I mean, you have time to think and look at the law. Like what I do, looking at organizational psychology and how people really behave in the workplace versus what the legal standards are, they don't have time to do that. but I do. And so giving people those new theories that they can actually use going forward in those kinds of cases, I think is really the role of the Academy. Now that we should actually be sitting down and talking to each other, which we don't do as much as we probably should, at least when it comes to sexual harassment law, because we're scattered around and doing all kinds of things. But I think there's definitely a role for the Academy to come up with the theories and the way to get at the legal standards, how to modify them, make great arguments for why they should be modified that lawyers can use.
Oh, can I just say one thing, which is that I just remembered that the Virginia Readmission Act case was the brainchild of someone who read a law review article about it. Like, that was like literally not me, but that is where that case came. That was where that idea came from.
There you go, Richmond Public Law Review. This is why you guys are out there. Okay? All right. So, but publish these ideas that lawyers can use in real cases.
And I think that's a wonderful moment to transition to see. I always have questions, and I feel like we could talk about this as a foursome for a while. But I want to give y'all the opportunity to ask a question of our illustrious panelists as well. And we have mics across the room, so all you have to do is raise a hand. Trey McAdams, class of 2027.
That is correct. One thing that's been on my mind lately is we do not have a particularly friendly Supreme Court when it comes to civil rights through the U.S. Constitution. I'm wondering if, like in a post-Dobbs world, y'all's efforts have focused more on state constitutions and trying to go state by state and get some rights that maybe we took for granted and enshrine them that way, more so than, say, 10 years ago.
Yeah, yes. We have been working for the last several years to pass 3 constitutional amendments in Virginia. And that is, the idea is very much with this administration, we need to shore up our rights at home. Now, these have been in the works since before Trump came in the second time, but we are, you will see this if you are registered to vote in Virginia in November. We've got the redistricting election in April, but then in November there are 3 constitutional amendments on the ballot, and that is to protect and enshrine reproductive rights very broadly, from contraceptive, IVF, just sort of across the board. And the second is to restore the right to vote to people who have served their time. And the third is to protect all marriages in Virginia, because in 2006, Virginia actually passed a constitutional amendment declaring that same-sex marriage is not legal in Virginia. It was unnecessary. Same-sex marriage was already illegal in Virginia. And of course, it had no effect once we got the decision out of the Fourth Circuit and then the U.S. Supreme Court in Obergefell. But given what the Supreme Court at the U.S. Supreme Court is, we understand there is a reasonable chance that that case could be overturned, and we want Virginia marriages to be protected. Second, it's also a deeply offensive message to send to Virginians that the Constitution actually says that it is our policy that same-sex marriage is legal. So we've been working on that. We are spending, just an enormous amount of time moving those across the finish line and getting people. We was at a fundraiser for the repro amendment last night, and I think our budget's over $5 million to make that. They're big, ambitious changes that will make a huge difference in Virginia long term. And our goal is to show the rest of the country, what can a southern state do? A southern state can do some pretty amazing things to protect civil rights and civil liberties, and Virginia's going to show them how to do that. And I really believe, I worked at the ACLU back in the 90s, and I felt like our values were very different from Virginia values at that time. And I think over time that has really changed. Those constitutional amendments are all popular in Virginia. They will pass if we do our work, and we will enshrine in our Constitution that kind of protections for civil rights and civil liberties. I think that's really, really important now.
Can I add on to something like that? What we've done effectively in Arkansas is not so much Constitution, but we've done initiative acts. So we have really a great initiative act program.
What does that mean?
So people, you put it out to the vote to the populace.
Oh.
So I work on poverty work too. We've increased the minimum wage drastically. In fact, economists are watching us now to see what happens. By initiated act, the legislature wouldn't pass it. So we've gotten so good at populist causes through initiated acts that they're trying to cut back on our ability to do initiated acts. Sometimes it's not a constitutional amendment. If we have a populist system, a pretty populist system where, like California, we can enact laws directly from the people, and a lot of times the people will enact things that the legislature wouldn't do. Another way to get at it.
Any other questions from folks? Yes.
I have to ask a question of David since he's my neighbor across the street. Very, very curious to finally hear about what you do during your day job. How much do you interact with the city of Richmond, and what has that experience been like? And maybe both positive or negative examples would be of interest.
So the city of Richmond, among other things, owns the John Marshall Courthouse, which is where I typically practice, is where the Richmond General District Court is and the Circuit Court. And they definitely need to upgrade that building. So that's the first thing I would say. Actually, I think the Circuit Court judges are taking up arms against the city about the inadequacy of the John Marshall Courthouse. So that's one way I interact with the city. But also, to the credit of the city, they've been increasing funding for our work broadly in legal aid, specifically in access to attorneys for people facing eviction in Richmond. I think that the widely reported stats about Richmond being one of the highest eviction rate cities in the country has really moved our local elected officials to try to do what we can about that, which one of the few things you can do, because the city can't really change landlord-tenant law. That's just the province of the General Assembly. But the city can fund legal services for low-income people. And let me tell you, there's a big difference between the law as it exists on the page and what actually happens in courthouses when one side has a lawyer and the other side does not. And so that's going to make a big difference as that funding continues to grow and we get more people represented.
Thank you. Do we have time for one more? Oh, any more questions? Well, I will ask another question, because it seems that we have these federal issues, but from what I'm hearing from the three of you, is that state and local, though, is where a lot of the immediate change can happen, or where the change that affects day-to-day lives occurs. So how do we stay focused on the state and local when the federal is what is just so filling all of the media and taking the air in the room?
I mean, I would argue you have to focus on both of those things.
Okay.
We're still suing the Trump administration, as often and as aggressively as we can. We've brought a bunch of cases on behalf of immigrants who've been picked up in Virginia. And we have a case against the DODEA, which is the Department of Defense schools that banned a bunch of books. So, I mean, I think I guess I don't know what the answer is to that. I really like strategic planning, where you kind of lay out, we're going to spend time on these things and be really disciplined about it. But I think from our perspective, we have to do both of those things, and that's really hard.
You're having to always engage on multiple fronts.
Yeah, I mean, and it changes a lot. The history of this is 4 years ago, probably we would have said the federal administration we can make a lot of things happen behind the scenes with regulations, and in the state, the governor was vetoing everything we got passed, and now we've sort of flipped where we're able to get things passed, and the federal administration is unbelievably hostile to our folks. So you really have to, I guess, be prepared to pivot in that way.
Any other closing remarks?
Many of you law students will end up being attorneys, believe it or not. And your day job might not be legal aid work, but there's always an opportunity to do it pro bono. And so I highly recommend that you do that, because it'll change your life, and it'll change the lives of your clients. It'll make your life better. So please do that.
I agree. I'll piggyback on that too. So I think one of the most effective I've ever been was as an associate doing a pro bono case where I got a state trial judge overturned in California for the gender bias he showed the plaintiff in a case, in a sexual harassment case. So sometimes those pro bono cases can set real important standards going down the road. So do that work. Don't forget to read the law review articles every once in a while. Every once in a while we have a good idea.
Well, thank you to the three of you for joining us today. I truly have learned a lot, and I imagine that everyone in the audience has as well. Thank you.
Okay, without further ado, I'm going to introduce Professor Jonathan K. Stubbs. He writes at the intersection of race and human rights and teaches in the areas of constitutional law, human rights law, race, religion in the law, and professional responsibility. He has authored and edited several books, including the autobiography of Oliver Hill, The Big Bang and Beyond, the life story of Oliver W. Hill Sr., as well as co-editor of Memoirs of the Honorable Henry L. Marsh III, civil rights champion, lawyer, and public servant. Professor Stubbs has also authored a first-hand account of his challenges overcoming prostate cancer titled Out of the Boat, Trusting God in the Midst of Life's Storms. With the late Oliver W. Hill, Professor Stubbs has written a book presenting a historical overview of race and the law in the United States, beginning in colonial Virginia, titled No Clue. White American affirmative action exists and demands a moral revival now. He's also got to do other fun things in his capacity as professor at the University of Richmond, such as leading a trip to Ghana with students. He authors law review articles on human rights in the United States and internationally. Professor Stubbs is here today to discuss his scholarship on the civil rights movement, movement lawyering, and the potential of seeing, practicing, and creating law through love, with the thesis that personal transformation is the key component of constructive societal change. Thank you, Professor Stubbs, for being here, and I will give you the microphone.
Good afternoon, everyone. I thank God for life. I don't take it for granted. As Ms. Harker mentioned, I'm a prostate cancer overcomer, and so each day I am thankful that I'm able to share life on this planet, and I thank you for taking the time to be here today. Time is something that's very precious. You can't get it back once you have used it, and you've decided to take it and spend it with us here today, so I want to thank you for having done that. I'm looking for my dear bride. She was here a little bit earlier. She's been dealing with some medical issues, and she made it a point. Oh, here she is, my dear bride, who is here today. And I recognize the sacrifice that she has made to be here. It's not an easy thing, and it's not pain-free, so I deeply appreciate that. To the Public Interest Law Review members, to Ms. Aurora, Ms. Harker, to Professor Kraft, to all of those who put this program on, I am deeply, deeply grateful. And to take a moment of personal privilege here, and I'm going to take a few moments of personal privilege over the next 50 minutes or so. This is going to be my last year as a professor of law here at the University of Richmond School of Law. And as such, this is likely to be my last lecture, talk as a law professor here at the University of Richmond. And therefore, we're going to have some fun today. And so it is in that spirit that I would like to offer some comments on why 21st century lawyers must lead with love. Now and since I'm an older guy now, I've been here almost 3/4 of a century, I don't have time to waste. So I'm going to just kind of cut to the core And I'm going to try to stay with that throughout the course of this presentation. So why must lawyers lead with love? Why is that an imperative in the 21st century? Well, I'm going to ask a 20th century prophet, Dr. Martin Luther King Jr., to help us answer that question.
We neither have peace within nor peace without. Everywhere paralyzing fears harrow people by day and haunt them by night. And our world is sick with war. Everywhere we turn, we see its ominous possibilities. And yet, my friends, a Christmas hope for peace and goodwill toward all men can no longer be dismissed as a kind of pious dream of some utopian hoper. If we don't have goodwill toward men in this world, we will destroy ourselves by the misuse of our own instruments and our own power. Yes, sir. Wisdom born of experience should tell us that war is obsolete. There may have been a time when war served as a negative good by preventing the spread and growth of an evil force. Make it plain. But the very destructive power of modern weapons of warfare eliminates even the possibility that war may any longer serve as a negative good. And so if we assume that life is worth living, if we assume that mankind has a right to survive, then we must find an alternative to war. And so let us this morning explore the conditions for peace. And as we explore these conditions, I would like to suggest that modern man really go all out to study the meaning of nonviolence, its philosophy and its strategy. We have experimented with the meaning of nonviolence in our struggle for racial justice in the United States. But now, the time has come for man to experiment with nonviolence in all areas of human conflict. And that means nonviolence on an international scale. Now let me suggest first that if we are to have peace on earth, our loyalties must become ecumenical rather than sectional. No individual can live alone. No nation can live alone. And as long as we try, the more we're going to have war in this world. The judgment of God is upon us. Yes, sir. And we must either learn to live together as brothers, or we're all going to perish together as fools. Yes, as nations and individuals, we are interdependent.
Dr. King said that the judgment of God is on us as a human race, that we have got to learn to live together nonviolently as members of one human family. He says as brothers. I say as family, as brothers and sisters on this planet. He says either we're going to live together as a family, or we're going to perish together as fools. And of course, as we're on the eve of yet another war, that call for nonviolent conflict resolution, and of course law is an instrument to mediate conflict. And lawyers can lead with love, and now I need to talk a little bit about what leadership means, good leadership, and what love means, what love has to do with it. Now, we're at a Public Interest Law Review Symposium. And leaders, good leaders, ought to help direct change for the public interest, the common good, or as Oliver Hill used to say, the common weal, W-E-A-L. That the law should help shape progressive change as opposed to being an obstacle. And indeed, the law should be the servant of justice as opposed to the executioner of justice. And so the claim then is that if we're going to be good leaders, lawyers then need to help shape the law for the public interest, for the common good. And what does that mean? Doggone it, y'all law professors, you keep asking these stupid questions. You just keep going on and on and on. And when we're talking about the public interest here, what I have in mind is to shape the law so that every single individual within our society has the best chance possible to reach his or her maximum potential during the course of his or her lifetime. In other words, somebody says, Stubbs, do you have precedent, historical precedent? Well, not quite, but I do have the founders of this country. And I can talk about how they helped to shape the law, but they had a kind of myopic view of for whom the law should work. They had a great deal of love, I want to argue. Oh, did I say I want to argue? Then that means like, we are in moot court, right? And you all could be the judges, and I'm going to try to make an argument to see if I can persuade anybody that the way the law should be interpreted ought to be such that each individual is treated as special and as special as the framers set up the Constitution and as the subsequent legal decision makers, including judges and lawyers and legislators, members of the executive branch, have interpreted the law, and it ought to be broadened, the application should be broadened, so that everybody is treated as special as possible, given the fact that we live in a civil society in which our rights have to be balanced in order for there to be some social cohesion and progress. Everybody can't do their own thing. Stubbs can't get outside. Well, I guess he could, but it wouldn't be a good thing. It's just to have Stubbs outside of your bedroom window at 3 o'clock in the morning, turn it up, as in the music, when you're trying to sleep. But it's not freedom, no. We have to have balance. We have to have some limits. So I'm arguing that law ought to be interpreted and applied for the public interest in that kind of broad sense, and that lawyers should have that as their kind of guiding principle. Historical precedent, Stubbs. Do you have any historical precedent of somebody who has done something like that? Of course. Ms. Harker mentioned it. Oliver Hill. Oliver Hill wrote an autobiography, published it in 2000. Most people in the state of Virginia, many people across the country, knew who Oliver Hill was. Born here in Richmond, Virginia in 1907, raised in the first 6 years of his life by his great-grandmother and a grand-aunt, his mother working for the hotel industry, and then subsequently Oliver Hill decided to go to law school to prepare himself to be a lawyer. Why? Because he said that as he was growing up, there were some things that stuck in his craw. That's a kind of Virginia saying, stuck in his craw. I'm from a small town in Virginia, Middle Peninsula. That's a real saying that I'm familiar with, stuck in his craw. In other words, it ticked him off. It made him angry. The way in which people who looked like Oliver Hill were treated. For example, what are you talking about? Well, in Roanoke, Virginia, Oliver Hill had moved there with his mom and his stepdad at the age of about 9. And then as he was entering middle school, he wanted to play basketball. But where could he practice basketball? Because under the law, there was no high school for blacks in Roanoke. Where do you practice? Well, you have to go down to an auditorium and you move all of the chairs and stuff. And you have some semblance of a basketball practice. You don't have any showers to practice at 5 o'clock, 5:30 in the morning. And yet the white kids had gymnasiums, basketball courts, showers. For Oliver Hill, this wasn't right. So he had, and this is one of the first points I want to raise, he had within his heart and within his mind a determination to be uncomfortable with injustice, with inequity, and to do something about it. And so Oliver Hill said, somebody needs to fix this. He said to himself, I am somebody. And so he went to Howard University, and then, oh my gosh, his step-uncle died, and his step-uncle was a lawyer, and the step-uncle's widow gave Oliver Hill his law books. And Oliver Hill read the books and said, as he read the cases, the Supreme Court, and we just heard in this previous panel about a hostile Supreme Court, Oliver Hill said the Supreme Court in Plessy versus Ferguson has lost their cotton-picking minds. And so he decided that he needed to go to law school and help the Supreme Court recognize this error in Plessy and to correct that. It just so happened as he started Howard Law School, there was another gentleman in his class named Thurgood Marshall, and they were mentored by Charles Hamilton Houston, a brilliant African-American lawyer, first African-American to become a member of the Harvard Law Review. They had a long-term plan to challenge Plessy versus Ferguson. Fast forward a little bit more. Lots of details that maybe they come up in question and answer, but I just want to give kind of an overview because we want to get to this point about the lawyer's need to lead with love, and that requires a personal kind of transformation, a regeneration of the spirit of the individual. What happens is that when Oliver Hill comes back to Virginia to practice law in 1934, he begins to work at the community level, taking pictures of the decrepit schools that African Americans attended, to compare those with the much better schools that white persons attended, and trying to build momentum at the community level for systemic change. How did he do that? Oliver Hill was the chair of the nominating committee of the Virginia NAACP in 1935. When the NAACP was organized in Virginia, Mr. Hill was the chair of the nominating committee, and his law professor, Andy Ransom, was the organizer of the convention itself for the NAACP. Okay, we're back in business. We're going to click. You want to hear the speech now? No, gone by that now. All right. And so Oliver Hill helped to organize people at the community level, preparing them for change. But there was a problem. The Great Depression. Mr. Hill couldn't make it financially as a lawyer in Roanoke. He'd just gotten married, moved back to D.C. And that's where his wife was living. They were kind of commuting back and forth. And there, Mr. Hill worked, again, organizing on the railroads. How? As a waiter. Mr. Hill had been a waiter in college, so he helps organize the waiters into their own union. Comes back to Virginia, 1939. When he gets back, sets up a law firm, serves in World War II, comes back again after the war, looking for the second victory. The first victory was over fascism, the Nazis. And the second victory was to be over segregation and white supremacy and the inequity of the law. Oliver Hill's classmate, Thurgood Marshall, made this statement. And this might be something that lawyers in the 21st century might use as a kind of guidepost as they're practicing. Thurgood Marshall made this statement in 1969. See, I've skipped ahead now. We were back in 39, we're back past World War II. But now, in terms of a moral standard, Thurgood Marshall says our country is based on equality, that all men are created equal, or the 14th Amendment, which is actually a conjugation of the Judeo-Christian ethic of the equality of man, his individual equality. Thurgood Marshall says the 14th Amendment is a conjugation of the root moral basis of this nation. We talk a lot about the Judeo-Christian ethic. And Marshall says that you can't destroy that, the ethic, by setting up one group as superior to everyone else. And that is the root of what we might call anti-love. When we have a group that is set up as superior to everybody else and has special rights and privileges. Can't do it and say that that's consistent with the 14th Amendment, the joining together of the Judeo-Christian ethic. But what is the Judeo-Christian? Stop, you keep asking these questions, doggone it. What is the core of the Judeo-Christian ethic? One might say, the first rule is love the Lord your God with all your heart, with all your soul, all your mind, and all your strength. Deuteronomy. From the Hebrew Bible. And the second, also from the Hebrew Bible, from Leviticus, love your neighbor as yourself. Jesus says that these form the core of the good news that he offers. But that's kind of airy. You've got to say, well, what does it look like in practice? Oh, good. In everything, do to others what you would have them to do to you, for this sums up the law and the prophets. Treat other people the way you want to be treated. Be fair. Be just. Be even-handed. Just do that. I said to one person, as my wife and I were checking into a hotel, I was talking to the receptionist, and we got on this issue of the world would be so much better if people just lived by treat other people the way you want to be treated. Another way of saying it. And she said, but suppose if when we say love your neighbor as yourself, the person doesn't love himself, doesn't love herself. Then what are you going to do? And this is where iron sharpens iron. So we're going to have some question and answer a little bit later. And you're all going to help sharpen up some of the comments that I'm making. They need a lot of sharpening. And it occurred to me, well, what you have to do then is, if the person doesn't even love himself, love your neighbor as yourself, you don't love yourself, then you should at least try to treat your neighbor like your neighbor is very, very special. You may not love you, but you can still treat your neighbor as though your neighbor is very, very special. So, my argument then is, looking at this 14th Amendment, conjugation of the Judeo-Christian ethic, and my argument is that it's not the words of the text, but what's written on the decision makers' hearts, which is most important. That's most important. We have lots of amendments. I'm in favor of amendments. Lots of laws. I'm in favor of that. But I'm also in favor of the decision maker, the judge, the lawyer, the juror, the member of the executive branch having something written in his or her heart that looks like love, that looks like treating everybody as though they're special. Everybody as though they were one of the founders of this country. Because there is a preamble of the Constitution which says, among other things, that we, the people of the United States, in order to form a more perfect union, it talks about establishing justice, providing for the common defense, and promoting the general welfare, and securing the blessings of liberty to ourselves and our posterity, that everybody, every single person ought to be treated like they're special. With the preamble telling us how to interpret the Constitution. The preamble says, listen, let me tell you about what's coming and what to do about it. We're forming a new country, and we've got some principles. And there's justice, and the general welfare, and the common defense, and liberty. So everybody should have it. But the argument is that if the First Amendment of the Constitution protects the rights of closely held for-profit companies, Burwell versus Hobby Lobby, a case involving whether or not the First Amendment rights, the religious rights, freedom rights of a for-profit, closely held corporation, the people who run the corporation are offended by the fact that that their corporation has got to provide contraceptions against their religious beliefs. And the court says that Hobby Lobby, this LLC, a fictitious person, a fake person. Did I say fake? I'm sorry. I can't say fake. Has the same rights as real live human beings. Following in the footsteps, really, of Santa Clara County versus Southern Pacific Railroad, a case decided in 1886 in which the Supreme Court of the United States said that the Southern Pacific Railroad was entitled to equal protection of the law as a person under the 14th Amendment. And of course, we all know, I mean, this is common sense, that the Civil War was fought to free railroads from oppression, and therefore the 14th Amendment would apply to railroads. The Equal Protection Clause of the 14th Amendment would apply to railroads. And so the argument is really simple, that if we can be somewhat ingenious in our interpretation of the law to protect things like corporations, then the Constitution has words in it which can also be interpreted to protect real people. Words like what? Like life and liberty and due process of law. Oh no, we can't interpret it like that, because if we say that there's a right to education, that means somebody's got to pay for it. We wouldn't want that, would we? I'm sorry. I digress. I want to give an example of lawyers leading with love, and this is a 20th century example. I want to lift that up as an exemplar of what maybe lawyers in the 21st century should be thinking about. This young woman here is the late Barbara Johns, Prince Edward County, Virginia. Barbara Johns led some of her classmates in Prince Edward County, Virginia, who were attending the Robert Russell Moton High School, a school for black kids in Prince Edward, on a school strike. Why were they on strike? Thanks for asking that question. This is why, one of the reasons why. This is what it was like to attend Robert Russell Moton School in the wintertime. You got a potbelly stove. Somebody's got to feed the stove some fuel. What you can't see is the leaky roofs. When it rains, some of the students would have to come to school with their umbrellas, tracking through mud. And some of these little structures where the students were learning were mistaken for chicken coops. This tragic incident occurred 1 month before Barbara Johns led those students in her classes out on a strike. Riding a decrepit school bus to school, a group of students headed to Robert Russell Moton High School found themselves on a bus that broke down on a train track with a train coming. And 5 children were killed and many more sent to the hospital in March of 1951. So Barbara Johns and her classmates felt, we've had enough. We want a no school or none at all. So Barbara John writes a letter to Oliver Hill and Spotswood Robinson, Mr. Hill's law partner, and also Martin A. Martin. It was a 3-person firm. Gentlemen, we hate to impose as we are doing, but under the circumstances that we are facing, we have to ask for your help. Due to the fact that the facilities and building in the name of Robert R. Moton High School are inadequate, we understand that your help is available to us. This morning, April 23rd, 1951, the students refused to attend classes under the circumstances. You know that this is a very serious matter because we are out of school. There are seniors to be graduated, and it can't be done by staying at home. Please, we beg you to come down at the first of this week, if possible Wednesday, April 25th, between 9 a.m. and 3 p.m. We will provide a place for you to stay. We will go into detail when you arrive. And then they call Oliver Hill and Spotswood Robinson on the telephone. Mr. Hill answered the phone and explained to them, you've done well going out on strike, but we already have a case. It's down in South Carolina, in Clarendon County. It only takes one case to establish the precedent. You all have done well. go back to school, graduate. We'll take the South Carolina case. But Barbara Johns and her colleagues, they weren't having that. They pleaded with Mr. Hill on the telephone. And Mr. Hill and Spotswood Robinson, and here's something again to be thought about for lawyers who want to lead with love. Mr. Hill said we didn't have the heart to break their hearts on the telephone. Mr. Hill and Robinson decided that they would go to Prince Edward and they would meet with the students because they were going to Christiansburg on the way on another case. They met with the students and their parents, and they were impressed. The students' morale was so high that they decided against, and the previous panel was talking about sometimes there are conflicts of interest between the lawyer's representation and that of the client. Against what the lawyer's better judgment was, they took the case. This was a student-initiated situation. Why did they take the case? Because the students had a real argument, and it needed to be done. Sometimes it's costly, though. It's very costly. It's costly. It cost Oliver Hill a lot. From 1947, this World War II vet who had served honorably and was discharged, been in the European theater after D-Day, could not answer his telephone at night because somebody would be on the other end. We're going to kill you. And they certainly, Mr. Hill and his wife, would not allow their son to answer the phone and pick it up and have somebody say, we're going to kill his ass tonight. We're going to get his ass tonight. That kind of thing. So it was costly. And then Prince Edward County was not the most progressive venue to bring a lawsuit. And so lots of people lost their jobs. Leading with love can be costly. Oliver Hill's law partner, S.W. Tucker, later on, was threatened with disbarment proceedings. Why? Because he was the lawyer, the chief legal counsel for the state NAACP. And S.W. Tucker's colleagues at the bar decided that he didn't need a license to be doing what he was doing in Virginia. Charges were brought against him. He's running and capping, solicitation. 3-judge panel meets in Surrey County, finds Mr. Tucker not guilty. So they didn't take away his license. They found that on a real estate matter, there was something objectionable that he had done, but didn't cost him his license. Leading with love means you got to be willing to make sacrifices. You got to have guts. You got to have compassion. So Mr. Hill took this case. Now, how much time do I have? Not much. That's probably a good thing for y'all. I want to give you an example of a contrast to the lead with love example of Oliver Hill. Because there have been other lawyers leading other movements in this country as well. Not a movement that's looking for liberty and justice for all, but rather movements that are looking for liberty and justice for a few. That too is a movement, you know. It's an attempt to effect social change through the law. So who might we be talking about? Well, the persons who created the Constitution that Oliver Hill and Spotswood Robinson and S.W. Tucker were fighting to have interpreted as it should have been, but how was that Constitution structured? Oh, just one last, this is a moment of personal privilege. I told y'all I was going to be taking a few of these moments of personal privilege. This, by the way, It's from my hometown of Gloucester, Virginia. 1948. This is at the T.C. Walker Training School, the African American high school that my mother graduated from the year before. This was the outdoor privy, the outdoor bathroom that she and other students were invited to use. In contrast to that, at Bodytot High School, a couple of miles from where I grew up, these were the restrooms for the white students. This, of course, is Oliver Hill and his law partners. I'm going to briefly, headed the wrong direction, briefly mention the role of religion here and misleadership, but it has an important impact upon us in this country. Because remember, we were talking about Judeo-Christian ethic. And the leader of the Roman Catholic Church, Pope Alexander VI, in 1493 issues a papal bull. This is a kind of a bulletin, an announcement, a proclamation in which he, as the leader of the church, does, among other things, decide that because there have been islands and countries that have been discovered in which there was gold and spices and very many other precious things, he wanted to inspire further discovery. And so what does he do? He decides to grant, assign, it sounds kind of lawyerly stuff he's doing here, to Christopher Columbus and to the monarchs of Spain, all their dominions, cities, camps, places, and so forth, islands and mainlands to be found, that have been found and are to be found. Basically, he's given away the Western world to the discoverers. Now imagine, just humor me for a little while. You know, I'm an old guy and I'm almost out of here. And imagine if a Martian came, you know, outside the door there and said, I've just discovered this place. And I've got some papers here. You know, this Martian migrant, you know, he just discovered this place. He discovered this university. And I've got some papers that say that it belongs to me now. You all got to go. Imagine that. So you can imagine how the native people in Jamestown felt when the English settlers came and delivered similar message to them. Unfortunately, the message of the Judeo-Christian ethic, it really caused some people a problem. One of the problems was there are people being imported from Africa, and they are being held in bondage, and they're converting, they're accepting the good news. What's going to happen to them? They're brothers and sisters in Christ. Can you hold them? But of course. What a crazy question to ask. Yes, you can. Baptism doesn't alter the condition of the person. This is the law, of course. It's kind of a jurisprudential gerrymander. You know, the law it includes some people and holds them close to its bosom, and then there are other people like. And then what about enslaved people who decide, I want to be free? And they resist the slaveholder, the master. And the master, having to correct the resistant slave, actually kills the slave. Then what happens? Oh, well, don't worry about it. The law's got you. The slaveholder will be acquitted acquitted, free from molestation, no legal liability. Why? It cannot be presumed that malice should induce any man to destroy his own estate. Now, if I had a pen or something, a victim. Don't get excited. It's just it's a thing. It's a thing. Don't get excited. If you kill an enslaved person, he's a thing. Well, don't worry about it. We got you covered. You won't have to pay anything unless maybe you were the sheriff and you killed the slaveholder's slave. Then somebody's got to pay for that. The slaveholder has lost some money. Who's going to pay for it? It's going to be paid out of the treasury of the colony of Virginia. Kind of the legal gerrymander is working here. There were some people who didn't feel like that was a good thing. This is an example of good leadership. We talked about leadership, lawyers leading with love. John Woolman decides that he's not going to write a will for a person who wants to convey an enslaved woman to somebody else. He's not easy about that. He's a Quaker, member of the Society of Friends. No, I'm not going to do that. However, as we get closer to the revolution, I'm just about out of time. I think we're going to have to hold it in just a minute after we work with Abigail. You know, Abigail's a good name. A lot of people have heard about people named Abigail. Abigail Adams writes to her husband, John Adams, who is a lawyer, and she has heard about this revolution that's coming, and she writes to him on March 31st, 1776, about 4 months before the Declaration of Independence is promulgated in Philadelphia. She writes to him and says, by the way, in the new code of laws, which I suppose it will be necessary for you to make, I desire you would remember the ladies. Woo! Woo! Remember the ladies. And be more generous and favorable to them than your ancestors. I wonder what that means. More generous and favorable. Do not put such unlimited power into the hands of the husbands. Remember, all men would be tyrants if they could. And if particular care and attention is not paid to the ladies, we are determined to foment a rebellion. And we will not hold ourselves bound by any laws in which we have had no voice or representation. That sounds like kind of echoes of taxation without representation. We didn't have a say in this. We're not going to hold ourselves bound by this, Abigail Adams says. And John Adams replies, as to your extraordinary code of laws, I cannot but laugh. We have been told that our struggle has loosened the bands of government everywhere, that children and apprentices were disobedient, that schools and colleges were grown turbulent, that Indians slighted their guardians, Negroes grew insolent to their masters. But your letter was the first intimation that another tribe more numerous and powerful than all the rest were grown discontented. This is rather too coarse a compliment. A coarse compliment. But you are so saucy. I won't blot it out. Depend upon it. We know better than to repeal our masculine systems. Although they're in full force, you know that they're a little more than theory. We dare not exert our power in its full latitude. We're obliged to go fair and softly, and in practice, you know we are the subjects. We have only the name of masters. And rather than give up this, which would completely subject us to the despotism of the petticoat, I hope General Washington and all our brave heroes would fight. John Adams says to Abigail, but what does he say behind Abigail's back? To James Sullivan, one of his proteges, he writes to Sullivan in May of 1776, 3 months now before the Declaration, he says, "Depend upon it, sir, it's dangerous to open so fruitful a source of controversy and altercation as would be opened by attempting to alter the qualification of voters. Who is going to be able to have a say, to have a voice? There will be no end of it. New claims will arise. Women will demand a right to vote. Lads from 12 to 21 will think their rights not enough attended to. And every man who has not a farthing, not a penny to their name, will demand an equal voice with any other in all acts of state. It tends to confound and destroy all distinctions and prostrate all ranks to one common level." And then just a couple of months later, they would write, "We hold these truths to be self-evident, that all men are created equal, that they are endowed by their Creator with certain inalienable rights, that among these rights are life, liberty, and the pursuit of happiness, that to secure these rights, governments are instituted among men, deriving their authority from the consent of the governed." That's what they would say. But there's something going on, something else going on here. I hear this little buzzer pulling at me saying, "You know what? It's time for you to shut up because you can't cover it all. It's not going to happen. There's a whole lot more." Patrick Henry says to Robert Pleasant, another a Quaker in this community, I think in the Henrico area, Patrick Henry says he really can't defend slavery. "Would anyone believe that I am master of slaves of my own purchase, of my own free will? I am drawn along by the general inconvenience of living without them. I can't do it. I can't live without the slaves. I will not, I cannot justify it, but I'm going to do it." And finally, another lawyer, another leader of the anti-love movement, Thomas Jefferson writes in his notes on Virginia, 1782, "Are not the fine mixtures of red and white, the expressions of every passion by greater or less suffusion of color in the one, preferable to that eternal monotony which reigns in the countenances, that immovable veil of black which covers all the emotions of the other race? Add to these flowing hair a more elegant symmetry of form." See my flowing hair? "Their own judgment in favor of the whites, declared by their preference of them as uniformly as is the preference of the orangutan for the black women over those of his own species." Thomas Jefferson, regurgitating these travelers' tales, these fantasies, which leads him to conclude that he has a suspicion that the blacks, whether originally a distinct race or made distinct by time and circumstances, are inferior to the whites in the endowments both of body and mind. Inferior. Thomas Jefferson, great lawyer, says that's what he believes. He's suspicious that blacks are inferior in body and in mind, and helps to lay the underpinning for what would become the doctrine of white supremacy. Reinforces that. And this is how lawyers can be leaders of an anti-love movement, or maybe that's too harsh. Maybe we should just say that. It's a myopic law, and myopic love, and myopic law too. Myopic love movement, that kind of narrow love movement that says, I love people who look like me, think like me, they're in my social status. And I'm going to gerrymander the law so that we're in the in crowd and they're out. We're the cool people and they're the other people.
I'm in with the in crowd. I go where the in crowd goes. I'm in with the in crowd, and I know what the in crowd knows.
Well, oh gosh, I've only left 7 minutes for questions. Questions? Comments? Criticisms, observations? Concerns? Yes, sir.
It's never occurred to me before, but I wonder if when they write so obtusely, they realize what they're writing is wrong somehow, and then they're trying to hide it. I mean, what do you think about that?
Are we talking about the founders now? Right, this like this? I think, yes. I think they're embarrassed by what they're saying. They don't want to come out and say that these black folk are like apes. You know, of course, and nowadays they might tweet it out and, put somebody's head on they might do that. But back then, maybe they were a little bit more circumspect because it doesn't look good to come out and say that. To say that, on the one hand, we're talking about all people created equal, universal equality, endowed by their creator with unalienable rights. That these are rights that pre-exist government. If there was no government, people would still have these rights. And all the government does is come along and help to secure the freedom that people already have. The government is not like a big slot machine, that's passing out rights here and there, and you pass an amendment, you got a right, and you repeal the amendment, the right's gone. No, the right is there because of who you are. But then to say, we really didn't mean that. We didn't mean that for Abigail Adams. No. And we didn't mean that for the poor white guy or poor black guy or any guy who doesn't fit into that category. We don't mean it for any of the women. We mean it for us. And that's a myopic love. And the argument is that we need a transformation so that people see that we're all part of one human family. That everybody counts. Everybody counts. And so we don't just throw away people's lives. Oh, we're going to go over and we're going to take whatever we're going to take because we can get it. Like the Pope said, you all can go and take it. You can get it. If I had more time, I'd talk about Johnson versus McIntosh. I guess I must have more time. I'm talking about. It's a Supreme Court case decided in 1823 involving Native American land. And the question is, what title are Native Americans able to give if they are selling land? And the Supreme Court of the United States, led by one John Marshall, says, none! Native Americans been here, discovered by Columbus and others, have no title to the land that they've been on for centuries. Now lawyers and law students, we're talking property law now. That the Native Americans are bare licensees. They're occupants. That's all. Until their license is revoked by the superior authority. That's it. That's all they have. That's all they have. And John Marshall goes on to say that this law, or this title to property, has been established from the Atlantic to the river Mississippi by the sword. This is by conquest. Some cases there was a purchase, but also by the sword. Now, Marshall said we shouldn't talk about abstract principles and let that deter us from interpreting the law as we found it. What would there be an abstract principle? Thou shalt not steal. Thou shalt not cheat. Thou shalt not lie. Thou shalt not murder. Oh, I'm sorry, I'm in law school. I'm starting talking about this kind of stuff. Lying, cheating, and stealing. I have to go to divinity school. I did go to divinity school, but that's... I'm sorry. Thank you.
Thank you, Professor Stubbs, for sharing all of those thoughts with us. I wanted to remind everybody that his book about much of this topic is available. It's titled No Clue, White American Affirmative Action Exists and Demands a Moral Revival Now. So if you're interested in more on this topic, it is available to you. So thank you, Professor Stubbs. And this is for you. Thank you so much.
Thank you.
Last few closing comments, so I won't keep you all too long. Well, it's been quite the journey for us today.
From the halls of the powers that be to the homes of you and me. So first, I would like to thank all the speakers who came out here today to the symposium. We could not have done this event without them all coming out here and coming in with all their views on judicial selection, trust, movement lawyering. And I was incredibly impressed with the wide range of perspectives and experiences that we have seen here today. So real quick, could we get a round of applause for all those speakers who came in here today? Now, I would also like to thank all the members of the Pillar staff. First, I would like to thank my fellow symposium editor, Sarah Aurora, the editor-in-chief, Sarah Harker, managing editor, Claire Pitzer, where's she? There, and everyone else on the Pillar staff. Without all these people contributing, I don't think we could have gotten this program off the ground like we did. And without them, it couldn't have been possible. I'm proud to have been able to work with each and every one of you. And thank you all for your dedication and unwavering determination to make this event happen. I would also like to extend a thanks to all of our volunteers for all their hard work, checking people in, making sure that this entire event went smoothly. I'd also like to thank the members of the Dean's Office. First, I would like to thank Dean Perdue for speaking and for many years of service and dedication to this law school. I would also like to thank Mary Ruth Keyes, Maddie Graff, and Will Thompson. These members of the Dean's Office put an incredible amount of work into this program to make sure that we had everything we need for promotion, for reserving space, catering, and any kind of logistics you could imagine. I'd also like to extend a special thanks to Carl there in the back, our multimedia project manager. Without you, I don't think any of the technology here would work, so thank you. I'd also like to make a quick note that there is an evening reception For all those who are interested and don't have anything left to do tonight, that evening reception is going to be at Bar West on Grove Avenue. I believe the address is in the program. So if you all are not doing anything tonight, we would be happy to see you there. And as a final note, I hope this event has been insightful for the importance of truth in the judiciary and the importance of lawyers in serving in our community. For that's what we are first. We are servants and members of the community in court. And as we've seen here today, that also extends outside the court. I would ask you all to remember to continue to serve your community, whether it's here in the city of Richmond or somewhere beyond. I would ask you to keep trust with community. It is the bargain that keeps our society together, and without it, we would be lost. I hope to see you all at Bar West, and have an amazing rest of your evening. Thank you for coming to the symposium, and have a great rest of your night. Thank you.